It's now 10 o'clock, so I'd like to start the proceedings. Can I just check, can everybody around the tables hear me? My name is Trevor Croft, and I'm the inquiry reporter appointed by the Scottish Ministers to determine this appeal, of which this hearing session is part of my consideration. It's an appeal against the refusal of planning permission in principle for approximately 140 units of residential development, including access roads, open space and other associated development at land to the north of the former Wellwood Primary School on the A823 Wellwood, Dunfermline. Permission was refused by Fife Council and the appeal has been submitted by Omnivale Limited. I'm accompanied today by Graham Mason, who is responsible for our webcast of proceedings in line with common practice these days for open government. As well as being broadcast live, it will also be available in our webcast archive if anyone wishes to check a particular part of the discussion. Now, before going further, you're all aware the appeal has been with us since early last year and determination has been very seriously delayed by the COVID situation. Various proposals for a virtual hearing came to nothing, but now at last we're able to sit around the table, a situation that I know is welcomed by both parties. But COVID has not gone away, and we've circulated to you all detailed hearing attendance rules together with a risk assessment and hazard action plan. I think we have all your details for contacts. Full details are set out in the rules, but I must emphasise that the strict need for social distancing, maintaining at least a 1 metre separation at all times. Masks must be worn except when sitting at the table, and if there are any questions about COVID at any time during the hearing, please do not hesitate to ask. The appeal is being determined under the provisions of the Town and Country Planning Appeals Scotland Regulations 2013. Having considered the appeal and the documents submitted and the subsequent exchanges, I decided to hold a hearing session in order to complete my consideration of the appeal. The procedure notice for the hearing session set out the matters that will be considered today. These are known as the specified matters. In this case, there are two key matters, the transport appraisals and the developer contributions. The procedure notice also explained that no other matters relevant to the appeal will be considered at the hearing. While I will take account of those other matters and of all the written representations and submissions before me, as well as the various statements and documents lodged, I am satisfied that I either have enough information already or can gain any other information needed by written representations. So we will not be discussing other matters today. Just a few formalities. Please ensure that all mobile phones are turned off. I think you all heard the lady speak about the fact they're not expecting a fire alarm today. So if we do hear one, then it will be a genuine call and we will need to exit either the door at the side behind me or in that far back corner, and the assembly point is in the car park just down there behind me to the left. Now, if I could just confirm a note of whom I have taking part in the hearing. Mr. Thompson, perhaps if you'd like to introduce your team, please.
Thank you, sir. On my right, Sarah Bailey, a partner in Appleshaw Goddard, who's my instructing solicitor. Immediately to my left is Andrew McCafferty, the principal of Andrew McCafferty Associates, who has advised the appellants on planning matters since 2009 or thereabouts in relation to this site. Then there are three representatives from Stantec. First of all, Kirsty Davison, who's an associate of the firm V is at 181. She's a qualified project manager and chartered transport planner. She was with WSP in the transport assessment for the Next to her is Rawson Mackenzie, who's a senior associate with Stantec. He approved the transport assessment addendum, and he was with PPA, and has revised the fresh document in his explanation with Stantec. And then, fourthly, we come to Andrew Eichel. His CV is 337. He's another senior associate. Associate. And his expert modeling.
Thank you.
Uneven.
I was hearing three. I think as long as you're like, I should have just have said at the beginning, when you wish to speak, please press the button in the middle at the bottom, and when the light is on the top of your microphone, it is live, and please remember then to switch off when you finish, and you should hear everybody else's voice coming through the microphone on here. Mr. Burnett, if you would like to introduce your team, please.
Thank you, sir. To my immediate right is William Shand, who was the Strategic Development Manager of the Planning Service at Fife Council, who is responsible for dealing with the application, although he's now moved on to a different job, but he's here today to speak to that. To his right is Mark Barrett, who's the lead officer of the Transport Development Management of the Planning Service at Fife Council, who dealt with the transport issues for the council. To his right is Stephen Patterson, who is my instructing solicitor from Fife Council. On the corner is Malcolm Neal, the director of Sistra, whose speciality is in transport modelling. And on the end is Keith McGilvery, who's an associate at Sistra, who was the lead contact in relation to the transport assessments undertaken by Sistra.
Sequence of events. As you know, the appeal is to be dealt with by way of written submissions, along with the evidence on the specified matters at today's hearing session. A hearing was requested by the appellant, and I agreed to this because of the technical nature of the issues to be discussed that lend themselves to a two-way discussion across the room. Hearings are a way of letting each of you put forward your point of view, whilst also letting me get the information I need for my decision. The procedure is set out in Circular 6/2009, and from it you'll be aware that the format will be a discussion that I will lead, so that there will be no need for each of you to repeat the cases that have already been put forward. The points on which I require further information are listed in the agenda that was circulated to you by email on the 16th of November. Does everyone have a copy of that? If you consider there are any additional points that should be added, could you please let me know now? I did ask for any comments, there weren't any, so I assumed that everybody is happy with that. Thank you. As both parties are legally represented, which is not always the case at hearings, it may be helpful if I leave each to guide their respective parties' response to comments which are being made. I'd expect the discussion to find a natural way forward within the context of the issues, and I'd welcome comments and questions from any participants as the discussion progresses. Please bear in mind that I have to take a note of the discussion, and my ability to do this will be inhibited by the speed and nature of the exchange taking place, so please bear with me if I need a little gap at some stage to complete my notes. Interruptions or speaking over someone is not acceptable, and if there are any points anyone wishes to make, they should be conducted in an orderly manner through me, unless there's a natural sort of response to a point made across the room. Everyone will have a chance to comment and ask questions, provided those questions are relevant to the issues being discussed. I'll discourage any repetitive or irrelevant interventions, and it would further assist my note-taking if any specific questions could be addressed through me. I'll indicate when I consider there's been sufficient clarification on any particular issue, and we will then move on. Although the procedure is informal and there's no formal cross-examination of witnesses and no closing submissions, there will be an opportunity for each party to sum up towards the end of the hearing, and as is customary, the appellant will have the final word. I've already seen the site and visited the general area, but there will be an opportunity of making a formal accompanied inspection if either party wishes that. But we'll consider that towards the end of the afternoon. Now, I hope the hearing can be concluded today, but I'm conscious of the need to discuss all the matters and that there are contentious technical points that may take some time to consider. The room's therefore booked for tomorrow in case we need to continue. If anyone has difficulty in staying late into the afternoon, please advise me at the break. We'll take a comfort break mid-morning, and I would normally try and stop for lunch at an appropriate hour in the proceedings, probably between 12:30 and 1 o'clock for about an hour. And we can review progress later today and decide accordingly whether a second day will be needed. If it is, I'll need to instruct my office for tomorrow because Mr. Mason is tied up on another matter, but we have contingencies for another member of staff to come and deal with everything. Is everyone clear about those procedures? Mr. Thompson, do you have any questions before we begin?
No, thank you, sir. That's very clear and very helpful.
Mr. Burnett?
No, thank you, sir.
As we heard from Mr. Thompson, this development has been in the planning process for some considerable time. It was submitted as a planning permission in principle. I have the statements of common ground, which are extremely helpful to me, and I note in that a number of points within those statements where there is still a matter of dispute to be considered. The Council set out very comprehensive reasons for refusal of the application. From the point of view of matters which we're looking at today, it considered that the proposal is contrary to the local development plan and does not propose to deliver a portion of the Northern Link Road, that it does not follow all the principles set out in the allocation policy DUN 044 and policy 067 of the adopted 5 Plan 2017, that it's not designed to take into account links with the adjacent Colton SDA site, which I understand now has planning permission in principle, or at least a notice of intention to grant planning permission in principle. That there isn't full mitigation without the Northern Link Road, and that without it, the development plan for the Dunfermline area cannot be fully delivered. And then it concludes with references to the various policies which are met. It does not consider the transport assessment to adequately assess the individual and cumulative impacts of the development on the road network. It only looks at the intermediate junctions to the site and does not take a cumulative approach. And then again, references to the policies contravened. And then there's, in reason 3, there's connectivity and permeability for cyclists and pedestrians to the wider path network. It considers the application fails to provide footpath and cycle path connections to existing networks to the north, east and south of the site. And it says that without lack of these links, there, again, it will be contrary to the allocation policy DUN 044 of the adopted 5-Plan 2017. That's just a précis of the full reasons for refusal. Now, it seems to me, and we have the opportunity in a hearing to discuss these matters more fully, that there are many areas where it should be possible, with good planning, a bit of give and take, to at least try and perhaps come closer together than the apparent gap in the reasons for refusals would suggest. Whether or not that is possible, we will find out during the course of the day. We'll be looking as well for clarification from the Council in terms of the developer contributions which are expected, and there is some consideration or some concerns about the legality of those investments, the investment fund contributions, and there are legal opinions. I note from Mr. Roy Martin, which must probably be one of the last, if not the last, opinions that he gained before his untimely premature death. So there's a rather poignancy about that opinion. Now, the matters regarding the contributions include the North Link Road. There's now, I know, a suggestion that a through road will be accepted, the strategic transport interventions and the associated matters. On developer contributions, there's also education, but those are being dealt with in writing and are not part of the discussion today. Now, I wonder if we might start with the appellant, because there are views from the Council that I've just referred to, that the transport assessment, which has been put forward by the appellant, doesn't meet the requirements of the Council and deals very narrowly with the site itself, rather than taking into account the fuller situation in northern Dunfermline particularly, but the area of development in the area covered by 5-Plan, which, as you know, considers quite a number of sites. So perhaps, Mr. Thompson, if I could start with you and ask you particularly to address this matter of the adequacy of the transport assessment, looking particularly at the comments made by the Council that it really concerns too limited an area of the site itself rather than the wider area considered.
I think, sir, that I would invite Mr. Rawson Mackenzie to answer that.
I think to set out the scene for this, we need to go back slightly further than that, Malcolm, and Kirsty's going to set out the requirements on the TA from WSP history. So if you don't mind, I'll let Kirsty speak first and then I will join.
So I think taking it back to the various stages of this scoping was obviously key to the future development of any transport assessment. And the 2012 guidance, that's from N144, states that it enables developers to clarify whether the transport elements of their proposals are likely to be acceptable or whether additional analysis or measures So I couldn't see the red light, apologies. So notwithstanding the guidance, scoping ensures a sort of practical approach around open dialogue with the local roads authority, constitutes a diligent approach and ultimately or should avoid the undertaking of potentially abortive or inadequate assessment. And that was always the position adopted by the appellant, which I think is largely evidenced in the scoping correspondence. That's OMN 138. So scoping for the Peel Site 2016 TA, OMN 12, commenced initially with 5 council road officers as early as April 2014, and after a lengthy pause, recommenced in May 2016. The pause was due to a recommendation from road officers to hold off submitting a planning application until cumulative modelling was undertaken for the local development plan, and that would have been in the SDA TA 2015, document OMN 108. That delay was something the appellant was willing to accept, despite the disadvantages of the result of doing so. There was a recognition that this exercise would be disproportionate for the appellant, that is the undertaking of cumulative assessment for the whole Dunfermline area. And 5 council road officers stated in correspondence that obviously this is a lot of work, and a developer such as Omnivale would not typically wish to undertake this extent of modelling for such a small development. As such, a localised junction modelling approach was deemed appropriate for the 2016 TA. This was a pragmatic position, largely informed by the scale of the proposed development, which on the basis of 140 units at the time was anticipated to have a short implementation timescale, and which in the context of the then proposed Fife plan was likely to be operational well in advance of the larger sites, such as Wellwood and indeed the Northern Link Road being constructed. The thinking at the time for the transport assessment was to ensure an appropriate and site-specific form of assessment that would help identify any specific mitigation arising as a result of the forecasted development impacts. Further, with respect to the Dunfermline Paramix model, it wasn't deemed appropriate for the appellant to be beholden to the additional cost to use that model, but more importantly, the scale of the development would be too small to achieve much value from the model in junction, assessment and design terms, and therefore quantifying the level of impact. So at no time did 5 council road officers suggest that the TA, the 2016 TA OMN 12, would need to apply the Dunfermline S Paramix model. Scoping correspondence set out the appellant's approach to the transport assessment for the 2016 TA and sought to agree the key parameters for that assessment. That included the proposed vehicular access points, committed development, traffic growth and year of opening, trip generation, trip distribution, and the junctions to be assessed. That was 2 site accesses from the A8, 2 site accesses from the site onto the A823 and the Pilmuir Street, Broomhead Drive, Arthur Street mini roundabout to the south. The proposed access points into the appeal site evolved from discussions in 2014, and in fact initial discussions pointed towards a standard priority, which would be a right-left staggered junction if travelling from the west, such as the Wellwood site, to the other option of being a T-junction at the north end of Pilmuir Road, that's the A823, and using the disused railway line to the north of the site with the potential for a spur southwards into the appeal site. And that evolved further to the eventual need for a signalised, or for the need for an assessment of a signalised crossroads onto the A823. And this was at the request of 5 council road officers, but understood to reflect both the Wellwood site access onto the 823 being set. Now that was as a result of the interim planning application, which in the meantime, during the delay period, had set their access point, as well as a new alignment for the proposed NLR through the appeal site, as shown in the Fife Plan interactive map. That's as per an extract on page 3 of the composite plans, OMN 345. It was also indicated by road officers that the only network junction needing to be assessed beyond the site access points was the Pilmuir Street, Broomhead Drive, Arthur Street mini roundabout. provided the application was received at the right time. The implication or understanding of right time was understood to be following the submission of the Wellwood TA and Five Councils cumulative assessment modelling to inform the SDA TA 2015. So notably, the scoping correspondence and the delay in submitting the appeal site planning permission and principal application demonstrates a degree of trust and collaboration between the appellant and the council, but equally reflects the appellant's willingness to accept a delay, as well as the associated shortcomings of that. And those shortcomings really can be put down to a combination of financial and commercial shortcomings, but equally, things changed in the interim. As I referred to before, the Wellwood site had set the access point for their site onto the 823. In fact, 2 access points were set by that application, but that also constrained the options for access into the appeal site. And another complexity around Wellwood now being a committed development, and the difficulty from working with their transport assessment, where it would have been difficult to extract the development trips onto the 823, as well as the complexity of phasing as a result of the scale of that Wellwood site. In addition, there'd been no testing of those site access points onto the 823 by the Wellwood site. That was something that I think at the time confused the appellant's team, but also made things a little bit harder in terms of what was being asked by one site, not being asked with parity to another. So in touching on the complexity of development and network context, as I said, the scoping correspondence by email and letter was ongoing, and I think that did demonstrate a degree of two-way dialogue, open and transparent, which by and large was conducive at the time to agreeing an eventual scoping for the TA. But it also demonstrates the complexity of the situation we were looking at over a significant period of time in principally trying to define that assessment scenario. The complexity related to the 2 key points, the Northern Link Road and consideration of the Wellwood site as committed development. So firstly, in respect of the Northern Link Road, in 2016, there had been no feasibility or technical studies, such as a stag appraisal, an outline business case or viability assessments of alignment undertaken by Fife Council to inform a deliverable, to inform the understanding of what a deliverable alignment might actually look like. The only indicative alignments that we saw were included in the SLA 2011 TA, that's OMN 110, and constituted drawings undertaken by Michelle. Fife Council have not engaged with the appellant directly to discuss the status of the Northern Link Road and the ambitions of the Council, nor the implications for the appellant's site, and the scale of the Northern Link Road in itself, an ambitious infrastructure project and likely to have a substantial lead-in time to complete in full and therefore become operational in its entirety. Therefore, given the uncertainty of the delivery of the NLR at the time that the transport assessment was being undertaken, it was considered that the size and scale of the appeal site would warrant it would be built out well in advance of the NLR being operational. And therefore it was proposed and agreed in scoping correspondence with Fife Council that the primary access into the appeal site would serve the appeal site only and not operate as a through route for the purposes of the transport assessment. The indicative layout plan, OMN 06, that accompanied the planning application illustrated the primary route. It illustrated both access points, but principally the primary route into the site, and that it could ultimately form part of the NLR. It was conceptually proposed with the NLR design criteria and alignment in mind, and could facilitate a link to the former railway line at the northern boundary of the site at an appropriate point in time. However, as the primary access road would serve the appeal site only for the purposes of the transport assessment, it was always considered that the 2016 transport assessment, OMN 12, was in fact an interim assessment. Further, it was always understood that Fife Council were content with this approach at the time. Touching on committed development, a committed development scenario in transport assessment terms is one which includes the baseline traffic plus any additional traffic arising as a result of development sites which have planning consent but are perhaps not operational, aren't operational, as well as those sites entering the planning application either on discretion of the council or at least minded to grant. It was considered that a committed development assessment of the Pilmuir Street, Broomhead Drive, Arthur Street mini roundabout with a full build-out of the Wellwood site would be abortive. This was because there's not a situation whereby the Wellwood site can fully operate without the NLR in place. The wider network changes and associated implications as a result of the NLR becoming operational would be difficult to replicate in a localised junction assessment format, and the test conditions would therefore not prove a valid position from which alternative mitigation might reasonably be proposed. Fife Council had stated in the scoping correspondence that the results of the transport appraisal, SDA-TA 2015, and the Fife LDP modelling reports, that's OMN 109, concludes that the additional demand can be accommodated on the existing trunk and local road network and identified transportation intervention measures. That refers to the intervention measures that were identified in the SLA-TA of 2011. Hence, the undertaking of a committed development scenario assessment in this location and this instance would not be a constructive exercise, nor one that material infrastructure changes could be derived from. Finally, Fife Council road officers had also stated that the Wellwood TA had assessed the Pilmuir Street, Broomhead, Arthur Street mini roundabout, and that the conclusions would not be significantly different with additional trips from 125 dwellings. There's a difference in the unit numbers there because the 125 was the initial number of units that the appellant was considering for the site, and during the process of time uplifted to 140. So Fife Council had indicated in the scoping correspondence that the wider cumulative implications of the Fife Plan allocations on the road network have been fully considered in the Fife Plan TA, which should be referred to in the 2016 TA. And in addition, the outcomes of the SDA TA 2015, that's OMN 108, which assessed the cumulative impact associated with all the North Dunfermline candidate sites, and that is those proposed since the adopted local plan, and to the order of 3,000 odd additional units, did not identify the need for any additional mitigation beyond that in the SLA TA 2011. Therefore, it was always queried by the appellant as to the value of a committed development assessment at the Pilmuir Street, Broomhead Drive, Arthur Street mini roundabout, when ultimately the end position was known and that, in those circumstances, no mitigation was required. To move on to the impact of development associated with the appeal site, as I referred before, the trip generation and the approach undertaken to that, as well as the trip distribution, was agreed with Fife Council road officers. And I now speak to the contents of the 2016 TA OMN 12. The traffic volumes on the A823 in 2016 were circa 3,000 vehicles per day. That's a two-way flow. The trip generation associated with the proposed 140 units equates to 75 two-way trips in the morning peak. That's between 8 and 9. And that's 19 inbound trips and 56 outbound. And quantifying the 56 outbound trips, that's just under one per minute. So that helps to contextualise the volume of trips that we're dealing with. In the PM peaker between 5 and 6, there was 41 inbound trips predicted to the appeal site and 21 outbound, and a total of 62 two-way trips. The junction modelling for the two access points was based on standard priority junctions, albeit a committed development scenario which considered the interplay of a full build-out of the Wellwood site with the appeal site was assessed as a signalised crossroads arrangement, and that was to satisfy the request of Fife Council. It was referred to in scoping OMN 138 by the appellant. It is acknowledged that the primary site access may ultimately function as a signalised crossroads with the NLR, which would have a larger footprint than a simple priority junction, As such, indicative design drawings will be produced for both simple priority and signalised crossroad options for the main access. These indicative drawings will ensure that the land can be reserved for a future signalised crossroads arrangement, such that the NLR is not prejudiced and latter scheme refinements can be appropriately accommodated. A summary of development impacts on Pilmuir Street, Broomhead Drive, Arthur Street was only 3% with the appeal site traffic, and the modelling work showed the junction to operate with minimal delay and queuing as a result of the additional development traffic on the network. And indeed, the junction capacity assessments for the TA in full, including the site access points, which could be constructed to the design requirements to meet the throughput of traffic, would all work well within capacity. We have subsequently updated the impact assessment of the development, and that was a junction modelling refresh technical note produced by Stantec, document OMN 189, to support the submission of the appellant's hearing statement, but also to demonstrate the adequacy of the 2016 TA. So whilst broader parameters were not discussed with Fife Council, those that were originally agreed in the transport assessment were held, albeit updates were made to the year of assessment. So there was an assessment of the Wellwood site development traffic based on a refresh of the 2016 transport assessment analysis, and there was an assessment of the Wellwood site plus Colton, which we knew was nearing, it was already been submitted, I believe, for planning at the time. And we revised the year of opening to 2025 and undertook that assessment again. And I would refer you to the Junction Modelling Refresh document OMN 189 for the results. I think pages 22 and 23 of the hearing statement discuss the results or the junction modelling refresh. And even with those revised assessment scenarios, the junctions still continue to operate within capacity. There was no change to the trip generation of the appeal site at the time. But what it's worth noting is that by including the Wellwood traffic and now including the Colton as committed development, in effect it reduces the percentage impact of our development trips on the Pilmuir Street, Broomhead Drive, Arthur Street mini roundabout.
When you say reduces the impact, you mean because it becomes a smaller percentage of the overall traffic? But it's not actually reducing any traffic, it's just as the percentage in relation to the wider development.
That's correct, yes.
I'm grateful to I wonder if she wishes
Okay, thank you. In response to the documents that were prepared after the original TA, the TA addendum, which was prepared in 2017, which is OMN 18, tried to address the key points that were raised by the Council's roads officer. There were 7 of those points, which was A to G, some of which were feedback on technical issues and updates just on numbers. And I think it's worthwhile just being clear what those are. The changes in respect of the points were the capacity in relation to the site, moving from 100 to 140 dwellings. The second point being that there was an expectation that the original TA had assumed that the development is a standalone and small-scale development. We acknowledge that. It is a relatively small site in the context of the sites being developed in Dunfermline, and the wording was terminology, I suppose, in reference to the TA. Point C was about the development opening year, and again that was an update that was added and responded to in the TA addendum. The next point was about the Northern Link Road itself and the routing through the site and whether the NLR was committed or not. And again, that was our interpretation of the NLR being an indicative alignment, but obviously acknowledging that it was part of the LDP. Point E was an issue in relation to implementing additional off-site mitigation measures. Now, the original TA did not consider there was a requirement for additional off-site mitigation measures, and in fact, the junctions that were assessed, the immediate junction, particularly the one to the south, which is the Arthur Street mini roundabout, did not require any mitigation. So the references, we believe, to mitigation were more about the connection points from the site to make the site permeable and connect with neighbouring sites. And also there was some reference to the requirement for footway provision or cycleway provision and routes to schools, which we covered as a sustainable section within the TA addendum. Point F was in relation to a scenario which required additional development and committed traffic, which is what is referenced in OMN 189, which is the additional modelling that was undertaken. And point G was a point of contention about whether the framework layout drawing showed the NLR extending to the site boundary. So those points were all addressed within the TA addendum to expand and respond to the Council's concerns about the original TA, and were summarised in that document. There are key elements of that, I suppose, that would draw attention to, and in particular, point E, which is that it suggests that what we suggested in our addendum was, in the longer term, the Dunfermline North SLA development builds out and the NLR is constructed, there would be the ability to signalise the crossroads on the A823 and incorporate a pedestrian phase to facilitate crossing off the A823. That is, as Kirsty had suggested, if the NLR has to pass through the site to the Wellwood site, the junction being configured as signals allows a safe crossing from the site to the west. That is taken as read, and we acknowledge that. The issue that probably was not addressed in terms of a drawing and the intimation of the NLR was the NLR was shown indicatively to extend to the north-east of the site, but it did not on the drawing show it going to the boundary. And I think we acknowledge that was not because we said it wasn't technically feasible to go through the site, but we acknowledge that would be the approximate point at which it would connect or could connect to the Colton site. For the purposes of just summarising the refresh OMN 189 was 3 years apart from the TA addendum. So it was significantly later in time and picked up again issues to do with the modelling and the junction. So when I say junction modelling, testing of the local junctions rather than strategic modelling. And that was an update in terms of the original information that was just brought up to speed and forecast to a further point in time. So that document on its own is just to give an idea of the additional volumes, acknowledging that the Colton site was, I think at that stage, looking as if it was minded to grant. Again, the sensitivity of that was all about the 823, acknowledging that the trips from the site would pass to the south, and therefore the junctions to the south were the ones that would be at all sensitive to the development.
Perhaps. Sorry, Mr.
I hope so you feel that adequately answers your question at this stage.
Thank you. There's a lot there, I think, that needs a response to. Perhaps, Mr. Burnett, I could pass over now to the Council.
Thank you, sir. I think I'll probably ask Mark Barrett to answer in relation to the understanding of what was being asked for in the scoping initially, and then perhaps to Neil or Keith on the detail. But I don't know.
Yeah, thanks.
And then perhaps even Mr. Shand might comment at the end about the process.
This will be quite a short response, I think. There's a lot of points to take in there, but in general, most of what Kirsty said there, I quite agree with through the scoping process, particularly the scoping process. One point I would contest is I never told yourselves or your client that you should wait to submit a planning application. I said you should consider it, but I have no powers to you can submit an application any time you want. I have no powers over that. When the initial approach was made in 2014, the planning application site was not allocated. It was at that time a candidate site for the forthcoming, then would eventually be the 2017 local plan. We had a 2011 TA looking at all the existing allocations within the 2012 local plan, but these did not take into consideration your appellant site or any of the other North Dunfermline SDA sites. It was suggested that if so there was two options available to the transport consultant and the client then. One, do the full TA looking at their site and the other candidate sites. Do the full work that we were intending to do, but we knew that was being a considerable expense, and there were no, that she said herself, they didn't want to do it. So after a delay of 2 years, the scoping started again. By this time, the 2015 TA was available. It had been signed off and agreed by Transport Scotland, the conclusions thereof. And what we specifically asked then was to look at the local implications of the development on the local road network, take an acknowledgement and cognizance of the 5-plan TA and its conclusions. Just specifically look at some. Yes, we did agree. Just look at the closest junction, which was the Broomhead Drive junction. So yes, I agree with all of that. There was an issue about trip distribution. I have made a mistake in that when I agreed to trip distribution, but I think I haven't got it in front of me, but it says along the lines based on existing traffic patterns in the area. I didn't pick up on that, and that was my mistake. I should have said to you, look at the existing decent junctions in Wellwood and base it on that. But that's my mistake, and it's been picked up on by my colleagues here. So I had a number of comments on the original TA, which was addressed within it, well, partially addressed within the TAA. The reason I asked for additional modelling work to look at the taking into committed work and the work that was going on in the Wellwood site was to try and do what we've done with every other TA in here, is to try and help inform the Council of when these intervention measures should be provided. Now, the TAA goes into a lot of reasons why you didn't do that, but I was satisfied at that point that there was enough information from there for me to make a recommendation on the planning application, which was actually approval, subject to conditions. Now, one of those conditions relates to, we'll be talking about later, the obligations and to make their contribution towards the strategic intervention measures. Now, that, again, that was happy enough with that. I sat back and I thought, I've seen the last of that one for a while. And until we got a late submission, no, we're not, from the appellant, we're not interested in the obligations, we're not paying them, we've got no interest in them. And at that point, the TA said, well, hang on a second, to say that you've not, you've got no impact on the development, as cumulatively as with all the other developments on the site, you've got to prove that. And that's what I say the TA does not do. The TA only considers yourself in isolation from the rest of what's going on with it, of all the approved allocations, and that's where my issue with it is, and that's when my recommendation changed to one refusal in 2018. And that's what. If you don't agree with the 5-plan TA, you've got to prove, you've got to show why it's not right, and that's not been done. And that's basically where I am at the moment.
So just to butt in there, are you saying that if the appellant, or perhaps the then potential applicant, had been willing to make a financial contribution towards off-site mitigations, then there wouldn't have been a need for further traffic studies? Is that a correct interpretation?
Yes, we did ask for additional bit of work to try and help inform the timescale for delivery of these identified stems, because the delivery timescale depends on which developments come in forward first, where the build out in all the individual sites, and we've been getting that with every TA for all the other larger developments, and it has been very helpful. So we've got a very good idea when each of these items have to be delivered, but we didn't get that with this particular one. However, as I said, there was enough in there for me to say, yeah, okay, if you've, and so there's a condition in there, or a six said, well, okay, if you provide the transport contribution to help the council deliver the stems, then it's fine, your development's okay. But they're saying, no, we're not going to prepare that. So I've now got a situation where I can't recommend approval of the application because they're not paying their fair share of the mitigation measures which are required as a result of development. So yeah, if they turn around now and say, I will pay the obligations, then my refusal would be withdrawn.
So just to be absolutely clear, in terms of the impact of the build-out of the site itself, which is allocated, as we now know, in the development plan, there's no inherent issue with that. The issue is really the developer contributions for the wider mitigation measures outside.
Yes, and at the time ensuring that the Northern Link Road passed through the site, so it linked with the adjacent sites, but that appears to have been addressed with some recent submissions. Is that correct?
Yes, I don't know. Perhaps Mr. Shand briefly, and then the more technical side of matters.
I think it might be useful just to put, I suppose, the traffic assessment into the context of the plan application, based on useful history that Kirsty and Ralston gave there with regards to how and when the transport assessment was scoped and then submitted. So I think there's a slight disagreement or confusion around what the scoping information states relative to how, I suppose, we dealt with plan applications in Fife Council. For the what you might term smaller sites, there was an understanding of the no necessity to run a full assessment of the Fife Plan TA conclusions, etc., for the costs and looking at the cumulative impact of that, because Fife Council had already done that work in accordance with the transport assessment guidance given by Transport Scotland. So from that perspective, the guidance always was from Fife Council in the scoping exercises to concentrate on the localised junctions on the proviso that we've already established the impact of those development sites on the STIM measures, and thereby the contributions would alleviate that identified impact of the sites alone. And that way, the localised impacts, which weren't addressed as part of the 5 Plan TA, which was a larger scale, could be addressed on the local issues, and also, as Mark sets out, the timing of those STEM and local issues. And prior to my role as Strategic Development Manager, which looked largely at SDAs, I was also lead professional that looked at the major applications in the Dunfermline area, and that was a consistent approach taken across the developments and in terms of transport assessment. Now, the reason and the establishment of that is on the basis that the developers pay their contributions towards mitigating that cumulative impact that the 5 Plan TA is established. Now, the timeline of this, again, looking at the scope and responses, I can see the consistency in the conversation between Mark and the appellant's team there, and that Mark is setting out that if you wait for this 5 Plan TA to be done, then that sort of global issue has been established, and thereby you can concentrate on the issues at hand of the local issues to your development site. But it's also expressed that sort of cumulative side with the development sites, as Kirsty set out, as being committed at that time, which was the Wellwood site, and what impact that might have from a timing perspective. So that is consistent in the approach that we've taken, and I can see that that is exactly what was being requested here. But that is on the proviso that the developer contributions being made. So from the timeline from thereafter, the transport assessment has been submitted to the application. The comments from Mark are made to the planning application, which raised some points which were seen as needing addressed by a new transport assessment, or at least an addendum. And those comments were passed to the applicant in the correspondence they provided, OMN 124, on 19 December 2017. So those are the TAA issues addressed, which then Ralston is set out as being addressed in the TAA. You will then note that it's not till the correspondence of around OMN 135, around 10 September 2019, that any conversation is then had around the applicant not willing to pay any contributions. So you can see that the TAA at that time does not address that issue that then arises by the contributions not being raised. So as a planning officer taking a decision on a plan application, I obviously just have to take into account the comments of my colleague as a transport consultant, putting his comments in, and that's a material consideration. But setting that into the context, obviously, of the planning obligations and contributions, that is one of a round of material considerations. Now, at that time, that is the first instance where we are of an understanding that the contributions are not going to be made as part of this application. So for my understanding, to understand, well, what does that mean in terms of this development site, it was at that time we then asked them, well, we need to understand what your impact is on the STIM. If you are saying that you have got no impact on the STIM, or that the 5 Plan TA is inadequate at that time, then the transport assessment that was submitted at that time does not address any of those issues. The transport assessment and the TAA does not assess any of the STIM measures within it. And for me as a planning officer to be able to agree with the appellant at that point that either one, their application site has no impact on the STIM measures, or two, that the 5 Plan TA does not address that or is inadequate itself, I would need a much grander transport assessment which individually assesses those STIM measures, which I did not get before me, because as I said, the TAA that came in addressed those points that Mark had made as part of his consultation response from 2017. So at that point, that's where the dispute arises in terms of the reason for refusal. There is no deviation at that point to say, here is your transport assessment that specifically assesses the impact of this development site on each of the STIMs to allow a planning officer to then say no contributions are required. Hence, the reason for refusal relates to that specific point. There's no individual or cumulative assessment. Now, the appellant's TA particularly addresses the point that, from their perspective, as there's no impact on their judgment on the first junction, which we agree with, that there then is no impact on the STIMs thereafter. Now, we would set out in the documents that we put forward that there is impact on the STIM junctions. Now, they are low, but they are proportionate to the overall cumulative impact. What the 5 Plan TA does is it identifies that there are STIM measures needed because of the global cumulative impact of all the development within the Dunfermline settlement and the surrounding area. But what we have proven that as part of those impacts, the development site contributes towards that. Now, as a global thing, it is a small portion of that, but it's within the realms of being an impact that is not de minimis because of the levels that are there relative to the other numbers. Now, you also have to put that in the context of timing, which Mark was trying to address, and what we've tried to address with other application sites is that because the STIM has a trigger point of a certain number of units or a certain number of trips that go through it, every development site that comes forward thereafter that may be smaller or larger will have an influence on when that trigger point is. The trigger point may state 200 units or 200 car trips, but that will be established by whatever application sites have been approved before it. Every site that comes forward and then puts through trips to that site, whether that's 2 or 4 or 10, obviously reduces the capacity that was already identified within those previous transport assessments. So what we've tried to set out in terms of our statement as well is that sort of global picture that occurred during this application, whereby we had the Broomhall SDA application that had a transport assessment and an approval at that time, or around that time, which then set out a number of trigger points that had been established through their transport assessment. Now, the numbers from this development site shown that going through the STIM measures would eat away at that already identified trigger points within that transport assessment. So while the impact might be low, it's got a consequence because it adds to that global contribution of car trips going through it. So in terms of the timing around how we got to where we got to, I think it's important to put in context that of when we were aware that the applicant wasn't of the opinion that they needed to pay transport contributions relative to the TA scoping and thereafter the submitted TAA. I think it's also important just around the suppose the crossroads arrangement in terms of the application site and when that came in, whether it was going to be the NLR or not. The crossroads itself created by the junction, as Kirsty set out, by Wellwood's positioning and then the applicant's positioning, because that's the 823, I think the council would have been of the opinion latterly within the planning application, because you were creating that crossroads junction by 2 access points coming out onto there, regardless of the NLR, it does cause a conflict whereby a signalisation was likely to be required because the traffic movement's on there. So again, as Kirsty's pointing out, because the scoping was happening at a point when there's movement within other applications, it was quite difficult to then pinpoint down what might happen. And again, as a planning officer, when the application then comes before me and things have moved on, there is sometimes going to be a need to request additional information or maybe amendment as a consequence of those other applications or approvals at that time. So hopefully that just gives a bit of context around the plan application process and then I suppose where the elements fitted into that.
So would it be fair to say then that in terms of calculating in financial terms what would be necessary, the 5-plan traffic assessment did or didn't give you sufficient information? Because you're suggesting that more information was needed by the appellant towards the off-site interventions, if I've got that correct. But was the 5-plan assessment not adequate in that respect?
The 5-plan TA established the need for interventions at specific junctions around Dunfermline based on the development sites within the 5-plan itself.
And are those the STIMs?
Those are the STIMs. That's what we refer to as STIMs. So those are identified as the cumulative development, and the 5-plan requires those STIMs to be created. Now, Fife is open to a developer coming to say that we don't need to make the contributions, but to be able to do that, they would need to show that they have no impact on those junctions that have been identified as a cumulative as being required. The 5-plan TA itself didn't set the figure that we've requested as Fife Council of a planning contribution. That was then done through methodology thereafter to inform the supplementary guidance document. But the 5-plan TA, what it does is it identifies that the STIMs are required on the basis that the development of the 5-plan encompassing it would require those stems. Now, as the applicant points out, one development site might not trigger that because it's not large enough to do that, but it's the cumulative of all. So from my perspective as a planning officer, I would have required the applicant, for them to say nil contribution, would need to prove that their application site did not have any impact on those stems or add to that cumulative impact on the stems, or similarly have an argument that the 5-plan TA was not adequate to prove that impact or prove that those stems were required. They would need to show either of those. And from my perspective of a planning officer, I would expect some kind of assessment of the development site on those stems, and that's all stems, because as we've set out in our planning statement, Dunfermline is quite a small settlement in terms of how it operates, in terms of the road network as well, and what's been shown in terms of the other transport assessment, even if the site's in the south of Dunfermline, it still has traffic impact on the north of Dunfermline and the east and west. So it wouldn't be sufficient just to concentrate your impact assessment on one area of Dunfermline, because it's likely that your traffic to reach an onward destination of Edinburgh, for example, being in the northwest of Dunfermline doesn't mean that your traffic isn't going to head to the south of Dunfermline or to the east of Dunfermline, where the stems really lie. The main aim of the stems is to alleviate the two traffic corridors that go through Dunfermline, west to east and north to south. And similarly, it provides two stand-aside, I suppose what you might call them, link roads that provide an alternative route along those, and that's the Western Distributor Road and the Northern Link Road. But our colleagues here who did the 5-plan TA might be able to give any further information around those particular impacts.
I'll just hopefully clarify things. The 2011 Dunfermline SLA TA looked at the then candidate sites, their impact on the local road network, and identified hotspots where there was problems. The TA identified strategic intervention measures to address these. The 2015 TA, and colleagues here can clarify, was a refresh of the 2011 TA and added all the additional land allocations to the site and to establish would the existing road network plus the stems still cope with the additional 2017 5-plan allocations, and it established that it would. So no additional stems were required as part of the 2015 TA, other than the Northern Link Road extending westwards through the Swallowdrum site and eastwards through the Hallbeath site, all part of the North Dunfermline SDA. Yeah, thank you.
In relation to the 5-plan TA, that Omnivale had been assessed as part of the exercise. I think my understanding is that the Omnivale was assessed according to its allocated status, 100 units at that. So, notwithstanding all other points being discussed today, that process hasn't evaluated the impact implications rather of 140 houses as now proposed. So there's a gap just there. That's a small technical detail to bear in mind.
Thank you. I'd like to come back to the appellant, but I think perhaps this might be an appropriate time for a comfort break. If we could perhaps just take 10 minutes, and please remember to put your masks on if you're walking about or visiting the loos or whatever. Thank you. So we'll come back at 11:20. And just to clarify my own understanding, there isn't any criticism of the appellant's TA in terms of its technicality or its professional conclusions. as I understand it. We have the 5-plan TA, which effectively clears all the development sites in northern Dunfermline in terms of their ability to be accommodated within the existing road system or with the addition of interventions. So the principle of the development, both in terms of the fact that it is allocated within the development plan and has been assessed in 5-plan, is not at issue. The question, and I appreciate we're going to develop contributions later, but the issue seems to be assessing the level at which the appellant should make a contribution towards the STIMs, the strategic transport intervention measures, if I've got that right, which would need further assessment on top of the TA to look at measures which are not perhaps readily identifiable through the 5-plan TA. Is that a correct understanding?
Also, I think there might be some slight technical criticisms of the applicant's TA in terms of trip per destination generation, but I'm not sure that's a major issue, but maybe Keith can speak to that. But otherwise, I think that's correct. So it's the real issue is whether the appellants have proven that they don't have an impact on the measures that require the STIMs, and whether the council have established that there is such a connection between the impact of the development and the cumulative impact on the STIMs.
Well, could we have any further comment before I pass over to the appellant, please?
So I don't believe there's any dispute in relation to the overall amount of traffic generated by the proposal at Omniville. My own view would be that the manner in which those trips are distributed onto the road network possibly understates the likelihood that trips from Omniville would then assign themselves through Dunfermline. The technical approach taken at the time of the TA preparation, as I understand it, looked at the total flow of traffic on the A823 outside the site and established a relationship between northbound and southbound traffic, giving rise then to a percentage of, I think, of approximately 50-50 split or thereabouts. I think it was 51-49, north and south. My view would be that that's not quite the same as having an understanding of the characteristics of trips, which then are end users of the completed development. People leaving their houses, travelling to work, travelling to school, etc., etc. We've evaluated that question using census data. My view would be that a more appropriate split would be a split which recognises the gravity of Dunfermline and the pool of either Dunfermline town centre or beyond, travel to Edinburgh, for example, travel across the Forth. Something more like 90% to the south and 10% to the north would be appropriate. And I think that's relevant because ultimately the question here is how many vehicles are being assigned left and to the south, and what's then the gravitational drag effect of those trips as they travel from the site to their destination. If lots of trips are leaving the site and turning north, then any evaluation of the potential for impact or the impact at junctions to the south is going to be understated. So the question of the distribution, I think, is quite important to understand. The more trips which head south, the greater the likelihood is that they top up or add demand to junctions which, through earlier evaluations, have been shown to be at or approaching capacity. And related to the question of distribution, I think then is the question of this pooling effect through the network. You don't get from Omniville to Edinburgh without travelling, without sort of transcending the network, if you like. So that particular point of distribution and assignment, I think is an important consideration here.
But to what extent would all that have been looked at in terms of considering the multiplicity of sites within the 5-plan assessment?
The 5-plan assessment in its evaluation of the Omnivale site will have included in it a forecast of distribution, which will have, I think, reflected the characteristics as I've just described. And the 5-plan in its own right, I think, should draw appropriate conclusions in that respect. I think the point I'm making is that the individual capacity assessments of the junction, Arthur Street, Broomhead Drive, which has been evaluated in the appellant's assessment, is the one which understates that or potentially understates that figure. And so when compared with 5-plan or when compared with modelling which had been undertaken earlier, there's a potential gap between the two insofar as we don't understand one of the broader paramics exercise, the 5-plan exercise, has looked at something that looks more like a realistic distribution, and the effects of that can be understood, whereas in standalone modelling, fewer trips are being sent in that direction, and the verdict therefore reflects that. So it just leaves this gap between the two.
So in terms of the stims that have already been identified, are you saying that they might not be adequate?
No, I don't mean to say that. In terms of the identification of stims, results from what I would suggest is an appropriate analysis of distribution. The appellant's transport assessment, which looks at individual, the standalone junction, proposes that trips leave the site and turn left and right, travelling north and south. So it's the verdict which emerges from that, which I believe understates the demand and puts greater distance, therefore, between what has emerged from STIM, from 5-plan and STIM modelling, and the verdict reported in the TA for Omnivale.
Thank you. Mr. Thompson, just before we broke, we'd been hearing about the council's situation in relation to the application itself and how the decision to, or the consideration that the approval should be recommended was then effectively altered because of the situation in relation to developer contributions. Now, I want to come on to the developer contributions itself, but perhaps would you like to respond on that general issue, perhaps taking into account what's just been said since?
Thank you very much, sir. Yes, I would like to do that, but if I could just suggest the sort of areas that I would like to ask Mr. Ralston about. First of all, I think that there's a minor factual matter, which is that in OMN 98, the council asked the then applicants, or rather sent them heads of terms, suggested heads of terms for the Section 75 agreement. That was on the 12th of June 2019, OMN 98. And the reply came back from Mr. McCafferty on the 21st of June in OMN 46. Enclosing, I think, a copy of Roy Martin's opinion. So it was clear, I would suggest, by the 21st of June 2019, that at the very least the appellants were having second thoughts about the developer contribution, if indeed they'd ever bought into the idea in the first place. But by then I would suggest that it was becoming clear to the Council that there was a problem on developer contribution. Then, sir, the topics I'd like to ask, I think first Ralston Mackenzie about, and then I think you'll want to pass on to Andrew Bagnall. Firstly, the significance of the trips which Mr. Shand has explained. No matter where a site is in Dunfermline, the odds are that sooner or later someone from that site is going to drive through every one of the stims. And the question is information available to show or to suggest whether that impact is significant or not? Looking at all the generated trips through any particular stims, how many of them would have come from the appeal side? And is that significant in relation to the cost of the stim at that particular point? So that's the first issue I'd like Mr. Mackenzie to address with help from Mr. Bagnall. Then the next issue is the question of signalisation at what I think would become a shared junction of the exit from the large Wellwood site to the west of the A823 and the section of NLR that would come out of the appeal site on the other side of the road, as it were. And I would like him to comment on that signalisation issue and who should pay for it and how it's factored into the Council's aspirations for recovering that money. And I think we've heard that signals probably wouldn't be necessary until such time as that became an NLR junction. In other words, they weren't necessary when the Wellwood permission was granted, and it's questionable, I would suggest, whether they're necessary as a result of comparably small traffic coming out of the appeal site. So there's that issue I'd like him to talk about. And the third is the point that was raised latterly by my learned friend about the trip distribution and the two views as to what the trip distribution from the appeal site might be. And I'd like Ralston Mackenzie to comment on, first of all, the difference of opinion between what we've just heard and what's contained in the TA. That difference, particularly in the context of the stims. Both in relation to the impact on the immediate proximate junctions, what was covered in the TA and the TAA and everything, and then separately its relevance to the stims.
Okay, there's a number of points. I think the first one that probably we should just clear up is we acknowledge the difference between the 100 units and the 140. But the clear message is that, as Mr. Barrett suggested, that the split of the trips on the existing network and using that for the assessment was acknowledged by the Council at the time as being appropriate. So the appellant and our team, there was no intention to mislead or downplay any movements to the south, not at all, because there was no fear of what would happen even if you reassigned them. Another key part to that is, and through detailed assessment of other TAs, is that the appeal site has used a mode share target of 51% which gives you a number of car trips from the site. The INH Brown Wellwood site has used a 41% target, which is the council's mode share target, which obviously influences the number of car trips generated. So there is another anomaly there in terms of the number of trips. To put that into perspective, the numbers we're talking about is the total trips from the site on the original assessment was 75 trips, of which 56 were outbound trips and 19 were inbound. If we were to look at that with a 41% mode share target rather than 51, which is what would be consistent with INH Brown, that would take the number of trips down to 61, which would be 45 out and 16 in. Now, whilst we're acknowledging those numbers change, they're not significant numbers that have a large bearing on the nearest junctions. And they certainly wouldn't have, at that volume of trips, a large bearing on the mini roundabout to the south. So I think we'll put that's point one. The second point in relation, probably easier to do the signals first, and then we'll talk about the relationship with the stims. The signals in themselves were, we acknowledge that signals give a benefit to safety in terms of movements across the 823. But in terms of the volume of traffic that passes through there are two key things. Initial TA would not have, if it was a standalone site, would never have required traffic signals assessed to the committee. And Crossroads Junction has dual benefits of the NL is lie. Michelle drawing that was prepared in 2011, Bolton site. At that time, that has effectively shifted and so the cooling capacity, but who's from can point as the junction about and to the closest considered a worse all the trips. The assignment the numbers that were stims were numbers. Mention
our understanding. The four the step. And published in one exception. So one or two. Application.
The number in the higher.
Just to clarify, I'm looking at your map on figure 1 in, I think it's OMN 108, which lists 3 stims at the Rumbling Well, William Street Junction, William Street, Pittencrieff Junction and Cole Road, Lovers Lane. it also identifies the mini roundabout, although that's not actually classified as a stim as such. Am I right in saying those are the three principal stims you're talking about?
That's correct. Those were the ones we picked out as being nearest in relation proximity to the site.
Does the council agree with that? Just so I know what we're
yes,
talking
except
about.
the Lovers Loan part. That's sort of not really part of it. It's difficult to explain without a map in front of me, I'm afraid. But the Western Distributor Road would skirt round the west of the Dunfermline and then through the Broomhouse that runs to the south of Pittencrieff Park. Very narrow. That's
we put up pens that could be used to point at them.
To do that, I myself. I mean, I've got the map up on here, possibly.
No, I think we acknowledge that the stims have changed in terms of reference over time, and that some of the original junctions that were listed became part of a group that were referred to as the WDR, I think, going forward, which is possibly where the confusion lies. But the principle of what was trying to be determined was to take the trips from the existing assessment and redistribute it to the nearest stims in.
Just been said by the appellant.
correct. Long time. These aren't out are off. New ways of working. Got the main policies and programmes, 5 regional. The old-fashioned. That's this. This doesn't exist in infrastructure. Measures to assist.
And it may show a 3% impact. That might have no consequence to that junction or the stim in itself. But from a planning perspective, when we look at the compliance with circular, that 3% then needs to be put into the context of the overall impact and the stim being identified. So if the stim has been identified as being required, that means that the threshold is going to be exceeded at some point. So then from a planning perspective, we need to consider the percentage impact of that specific development in that overall threshold. So that 3% on that junction is then put in that context, rather than whether that 3% equals the need for the STIM itself. So if you're looking at the significance of this development site relative to some of the STIM thresholds, for example, the Colton Plan and Permission were minded to approve sets a trigger for the Northern Link Road to be in place for 250 units. The Colton site sits adjacent to this site, and obviously the site sits at 140 units as being proposed. The Northern Link Road is there as mitigation for the town centre junction that's there. So if you put that in context of a threshold trigger, while I think the appellants put forward in the document 20 trips are likely from their development site to the town centre junction. So if it's 20 trips, in the significance of 250 units relative to 140 units, that's quite significant, although 20 trips would be quite low in an overall trip generation across the whole network. So it's got to be put in that context. I think that, as the appellant set out, the debate is around the significance of those trips. And the council argues that those trips are significant in terms of the overall cumulative global thing, and then that equals what the contribution level should be, which is proportionate to the size of the development. They pay, I think the contribution level required from this development is around 500,000 relative to the Wellwood site, which is in the region of, I think, 2.4335 million, which is proportionate to the scale of the development being proposed. So those are kind of the points that you need to put in context of some of the trigger points. And in the appeal statement that was put forward, I put forward a few other examples of that relative to some of the other STIM triggers. For example, the 250 units trigger that was at Wellwood for Pachivi roundabout, or I think 300. If you follow that along in terms of the table that we put in there of what the car trips would be from Wellwood to that junction at the 250 units point, the proportionate share of this development to when that trigger might be needed is fairly significant. And it just needs to put in that context that we absolutely accept as a council that it's a small development site in the round of 8,000 units that are proposed across the whole of Dunfermline. And as a consequence, the council are not expecting a large contribution relative to that whole thing. But if you put in the context of what £36 million of transport impact is and what a 1% share of that is of a 1% impact, that still comes out at, you know, around £400,000. So it's still significant because that whole needs to be made up. So if you set that in a planning circular context, if we were to accept a 1% impact equals no contribution, then another developer has to pick up that £400,000, which wouldn't be in accordance with the circular from that perspective. So it needs to be seen as who would then pay that 1%. And the consequence of the council would be as well that everybody could split their development sites up into smaller chunks and submit those transport assessments to say that there's no impact on these junctions as a consequence. So that's why the 5-plan TA gives you that base of here's the cumulative round, here's the mitigation measures that are needed for that. And if an applicant challenges that, then we need to understand whether they do or they do not have any impact, and we need that transport assessment from them to justify that.
So looking at the principle of the development, there is no issue. In other words, it's allocated in the development plan. It's a permission in principle which is sought. So any details can be assessed at the time of subsequent applications. The key issue, it seems to me, is really the one of developer contributions, which we're going to come to later. But is there anything inherent in the site itself other than the issue of the developer contributions and the related argument about the TA that would mean that planning permission should not be granted?
Well, I think so. There was the issue about whether it would prejudice the delivery of the NLR, but that may have changed through the appellant confirming that the through route will be provided, but we can come on to that later. Yeah, we need to clarify what that means. But other than that, there are minor aspects of the integration of the site, but again, I think they may be less of an issue now. I think as long as there's an indication that the links would link with the other sites and continue out, these are the sort of minor footpath and other links in the reason of refusal there. But I don't think that's a major issue. So.
Mr. Thompson, I want to come on to this question of the type of through road, which has now been, I think, accepted. But before I do that, have you any further comment on what Mr. Burnett has just said, or what I mentioned before? Now, there has been this long-standing issue of the Northern Link Road and the extent to which it should or should not come through the site. And there has been an indication from you, that from the appellant, that a road, if I've got the wording right, it was to Northern Link Road standards, could be built through the site. Now, that's slightly different to saying that the Northern Link Road could come through the site, but could you perhaps clarify exactly what your position is in relation to this?
Well, so I think the difficulty is that nobody knows what the Northern Link Road is going to be. It hasn't been assessed, it hasn't been engineered, nobody's planned it as far as we can see yet. So what we're offering to do is to build a road through the site from the A823 to the northern boundary to an NLR standard. Now, clearly, there's a similar obligation in the minded to grant consent to Colton because the viability of constructing NLR depends on the meeting at the site boundary. And I assume that we don't know yet whether there are minor workings that might necessitate shifting slightly one way or the other. But that's why the proposed condition was worded the way that it was, and to match similar conditions that the council's imposed on other sites. But the appellant's position is that that's the condition that they would accept. Their position is that it's more than is strictly necessary for their site, but they're prepared to construct it to this slightly higher standard, and the difference in cost would be reflective of any contribution that might be appropriate to the STIMs generally, although it can't be quantified. Yes, that differential. But as far as I can see, that there should be no doubt in anybody's mind that the piece of NLR across the appeal site would be there.
So I have OMN 06 and the plan on that, which I think was this one is an indicative layout. So this shows the through road on the, well, it's not a through road on this plan, it's a feeder road into the site. But in terms of what you've just said, you could theoretically have a road very approximately on this alignment, which starts opposite the access into the Wellwood site, but what may or may not be a signal junction in the fullness of time, and then presumably could extend from where this terminates now across into the Colton site to the north. Now, I accept this is purely in the sense of theoretical indication, but would that be the sort of thing that the appellant has in mind in suggesting this? And indeed, and would you have any objection then to that effectively becoming part of the Northern Link Road?
None at all, sir.
From the council's perspective, would that satisfy your aspirations in terms of the Northern Link Road in relation to this site?
Yes, sir.
So that, I think, resolves at least a point of principle that had been a difficulty in the assessment of the original application concerning the Northern Link Road.
Yes, sir. I think my learned friend was talking about the differential perhaps being offset against the contributions. We may come on to that later, but I think that's what's maybe set out in their
Indeed.
document OMN 310, but may come on to that later.
And then, although I'd actually got it on the agenda in terms of the developer contributions, but perhaps just whilst we're dealing with this potential layout, there's been concern expressed about the permeability and general connectivity within the site for pedestrians and cyclists. Now, there are, as I understand it on here, a number of potential link routes through the site, which are listed. We have 1, 2, 3 pedestrian links through to Colton and 2 pedestrian links to the existing development at Leedside Crescent, I think it is, to the south. Now, that's the appellant's drawing. In terms of the council,
Sorry, sir, can you just confirm which document you're looking
it's
at?
OMN 6.
6.
And I think it's the first plan, or MNN 06 to be pedantic. Which is an indicative drawing of how what the layout might look like. Please, thank you. My basic, and there's also a pedestrian link to the east as well. My question to the council is, do you think that would provide a basis for an acceptable solution for what the council is requiring in terms of the connectivity and permeability for cyclists and pedestrians? I'm not saying that's an identical blueprint, but are the principles which this follows ones which will be acceptable to the council?
The concern expressed around this plan in particular is that you'll note that the connections on this plan show onward connections beyond the site boundary. However, the applicant is unwilling to make those connections or accept a condition that would make those connections. So the concern with the council is, particularly in terms of the pedestrian link at the southern boundary, which shows a path that goes over to adopted road and footway, that connection wouldn't exist, that it would hit the site boundary and then the people would disperse over a grassed area and then get to the footway at the other side. So that wouldn't be a suitable connection point, because it assumes dispersion onto third-party land, albeit the council land, without the formal connection being made. So it wouldn't be suitable. And similarly on the eastern boundary, the connection again would be made to the boundary there and wouldn't actually get to the core path. And maybe on your site visit you might have noted that it's highly vegetated at that point, and the connection would need to be made to actually get to the core path. And similarly at that southeast corner, again, that disperses into sort of a garage reserve site. So again, it's not really creating a formal link that would be good enough for pedestrians and cyclists. So that's where the concern of the council is. We completely accept that those would be ideal locations for connections and would meet the design in streets in particular for connectivity and permeability. But without those onward connections, it's very difficult for a pedestrian or cyclist to then access the core path or the pedestrian network from there. So that's where the Council's concern lies.
Mr Thompson, does the appellant have any solution to this?
Well,
or indeed comments on that?
Well, so it seems to me that the first issue is to make sure that the links that are proposed by the appellant match the links that are proposed by Coulton or whoever the adjoining is. Approve both sites so that can happen. To it is that what the council would like to see involves works on the council's land, and it's not appellant why the appellant is responsible for site works nature. What the appellant is structures to provide the spine and core to join up with what's but can't control either the Coulton site or the council's land. That's, in a nutshell, the appellate position.
So that would be a matter of implementation, and clearly there are issues over works which are not either in the control of the appellant or on the appellant's land. But in relation to the overall development, these are not what I would have thought were areas of major difficulty that could not be resolved by a bit of imaginative thinking. Or am I being too optimistic?
I'll let Mr. Barrett speak in a second, but I would hope that would be the case, sir, especially considering that the council owns the land to the south and obviously wouldn't try and frustrate the development by any of its land holding, and the other matter does relate to the Coulton site, and there would be obvious need to
I mean, hopefully goodwill between developers would lead to a satisfactory solution.
May not even require goodwill if the conditions are sufficiently clear that the points have to be subject to approval by the council so that they can meet. But perhaps Mr. Barrett wants to say something on that.
Yeah, as the council owns the land, there's no need to purchase the land off the council. All they need is a licence to occupy to carry out the works. That's all that's required. We're not looking for the developer to buy the land. It's the path, these links are only required as a direct result of the development. So the council's not going to put a footpath up to a site boundary. So, yeah, nothing to add to that. But no, none of these are delivered. I take the points about the Coulton links. That will be dealt with through the ARCs, the ARCs, and making sure that these links, but the same thing would apply. It would just still be a licence to occupy to take it to the site, from your site boundary to whatever point it is. And we're talking about maybe an additional 3 or 4 metre length of footpath link to the north. These are very minor issues. And as you know, with respect, if you want to make these sites as sustainable as possible, you have to provide these links. If you're not providing footpath links, you're not providing cycle path links, it shows a lack of commitment towards sustainable transport.
Any comment, Mr Thompson?
Well, perhaps I should give Mr McCafferty an opportunity to comment on what's been said.
Thank you, sir. Can you hear me? I think this has been an area where we have discussed with the case officer before about the issue of whether you can construct something off-site. But certainly if we start with the southern side, and I think you'll see on your site visit, sir, that this is an indicative layout, bearing in mind that these are all matters of detail. But particularly for example, the first one, which connects with, or shows a connection to Leadside Crescent, the area doesn't do that justice as shown on the plan, but it is a car parking area, hard surfaced.
I'd seen that.
It. So there's a distance of maybe 3 or 4 metres between the appellant's site boundary and the curb which forms the boundary of the parked area. And it's grassed, and certainly I feel that there's no issue there about having to do any works. It's an area of grass which somebody could walk over. On the eastern end, that connection, in my mind, it's connection points the appellant is quite willing to accept. That term is different from a link, which implies to me off-site works. But coming back to the southeastern corner, there's plenty of opportunities along that boundary to form a connection point. There's a hard surfaced area, there's a couple of lock-up wooden garages, but not a problem in principle at all. On the eastern side, there is a gap, there's a distance of maybe 3 or 4 metres again between the appellant's eastern boundary and the core path. Now, that's encouraging to hear that the council will be willing to cooperate over that. But again, if that was problematic, connection can now be made to the north with the through road, so that somebody could walk and connect northwards to the core path. And just the last point is on the northern boundary. Yes, since the discussions originally took place of the application with the Colton resolution to grant, I understand that disused railway line is going to be infilled, and certainly at the eastern side there is no point, there's no problem about gradient or difference in levels. So overall, sir, I just thought it might be helpful. That's my comments on it.
Thank you. Now, in terms of the transport issues, the discussion this morning has clarified my own understanding of those, and I think probably now I have enough information to reach my own conclusions on these issues. That leaves us with developer contributions, but before that, has the council any final comment on traffic generally? There will be an opportunity at the end of the day for final summing up. But anything that they wish to raise as part of the discussion this morning?
I don't think there's anything to add at the moment, sir, but I think this will come back up again during the developer contribution discussion in relation to the sufficiency of evidence and the establishment of a link between the cumulative impact. But nothing further at the moment.
No, sir, I respectfully agree that there are issues that are likely to crop up in the course of the next chapter.
A little shorter. And we'll come on to developer contributions. Given the progress we have made, I would have thought we should be able to deal with matters this afternoon and not require a second day, particularly if it is going on a little bit, people are willing just to stay perhaps a little bit beyond 4 o'clock, which might be a normal closing time. Would parties concur with that?
I would expect so, sir.
Thank you. So I'll inform my office of that. So thank you for that discussion this morning. That's been very helpful. If we could return then at 1:15, please, and we'll move on to developer contributions, which might be a little bit more difficult than this morning. Good afternoon, ladies and gentlemen. It's 1:15, so I'd like to reconvene, please. And we now come on to item 6 on the agenda, which particularly concerns developers' contributions. I had listed 3 points that the discussion would include. Now, I think in terms of clarification of the construction of the internal through road, at least from a practical point of view, we've looked at that as we have connectivity and permeability within the site for cyclists and pedestrians. There's particular concern, at least on behalf of the appellant, about the legality of the contributions and their validity, particularly in terms of the development plan and the 2017 non-statutory guidance, which was submitted to ministers, but with which they had expressed concerns and has not been adopted. We'll also take into account various judgments and appeal decisions referred to. In that respect, I have particularly Council's opinion for the appellant, and I have the Supreme Court judgment on the Elsic case, and I also have the more recent FC 65, which was the appeal against development in Aberdour, which the Council refers to in its addendum. But I wonder if it might be helpful if, again, I could start with the appellant, Mr. Thompson, in terms of your concerns about the developer contributions, and let us see whether there's any scope for any accommodation or not between the different parties. Thank you.
Thanks, sir. I would invite Mr. McCafferty to explain our concerns about it in the first instance.
So what I'd like to do is go through and describe and explain what I understand to be the position and status of what we call the 2017 draft.
Yes.
So my starting point is that the draft was consulted upon in 2017, and this was approved for consultation purposes only at the Executive Committee on the 28th of February 2017, and there are extracts in OMN 348 of that. And the minutes of that meeting say that there was delegated power to the heads of planning to make non-substantive changes following the period of consultation. The next point really is that it's the report to the Executive Committee, which is on 184, on page 162, under the heading Legal and Risk Implications. Now, this statement said there was a risk of a policy gap if the supplementary guidance is not adopted. So the next step really is the draft, the 2017 draft, was submitted to Scottish ministers and on 61, and it was subject to a direction in March 2018. That's on 62. Now, the next key stage in this process, in our view, is the report to the Economy, Tourism, Strategic Planning and Transportation Committee of the 31st of May 2018, which is on 183. Now, that was a report obviously following the direction which had been issued by Scottish ministers. And there's no reference to the word direction in that report. There's no copy, as we can see, of the direction letter was attached to the committee report. I think it's worth looking in that document, so that's 183 at para 1.5. So that's page 17 in the report.
That's the page numbers on the bottom right-hand corner.
It is, yes, sir.
Sorry, what was the page number again?
It's page 17, para 1.5. And that paragraph explains that the February 2017 approved the draft version and some changes made and then submitted to ministers. And that confirms effectively that the direction indicates the Council could not move to adopt the supplementary guidance. Now, in that same report, 183, there's no reference that I could find to giving status to the outgoing draft. I think it would have been perverse if the Council had tried to adopt it as non-statutory guidance. Or they could have, through the direction letter, started work on or preparing new guidance, but they didn't. So this is set out in our hearing statement, paragraphs 2.89 to 294. So, moving on from this, neither the 2017 draft or the 2015 draft was adopted. And therefore, there is no development plan policy document available to justify or explain the levels of financial contribution sought by the Council. And again, that's discussed in our hearing statement, paragraphs 2.82 to 2.83. Now, just moving on to Circular 6 of 2013, which I think is OM 211. And if I can just get my extract of that document, Sir Andy. I'm just going to quote from page 35 in that circular.
Keep going.
Okay, sir. So I'm quoting from the table under paragraph 139 on page 35, where it says, suitable topics for supplementary guidance, and I quote, exact levels of developer contributions or methodologies for their calculation. And that's a topic which should be in supplementary guidance to fill in the gaps in the plan. This is not an appropriate topic to be called non-statutory planning guidance. Now, Section 22 of the 97 Act deals with supplementary guidance, and subsection 9, together with Regulation 27.2 of the Town and Country Planning Development Plan Scotland Regulations 2008, And that allows for adoption of guidance other than supplementary guidance by a planning authority in connection with an LDP, and then I quote again, provided that the matters dealt with in that guidance are not matters which may be dealt with in supplementary guidance. And in my view, sir, you can't use the label planning guidance for a topic that is meant to be set out in supplementary guidance. So the quotation that I cited just a moment ago, the exact levels of developer contributions, etc., is a topic for supplementary guidance, and the direction prevents this title from being used for what we call the 2017 draft. And the only status that the 2017 draft could have is as non-statutory planning guidance. But it's not been adopted. And Fife Council hasn't carried out that adoption process anywhere that I'm aware of. So the draft, the 2017 draft, is also described incorrectly as supplementary guidance in successive development plan schemes and, in fact, described as statutory supplementary guidance in successive 5-plan action programmes. And there's an OM reference there, so OM 210 is an example of that. So in my view, it's for the courts to decide whether something is a material consideration. It is a matter of law whether the 2017 draft is a material consideration. The appellant could not sign up to a scheme that is unlawful. It is for the council to satisfy the ministers that their document is lawful and complies with the tests in Circular 3 of 2012. Clearly the ministers directed the council not to adopt it, and they haven't submitted or prepared any new supplementary guidance to cover this matter. And that's 3.5 years after the letter, the March 2018 letter. In law, the period that the draft guidance can be considered as a material consideration ends at the date of the direction, i.e. 12th of March 2018. It then loses its status as a material consideration. In my view, sir, it carries no weight at all. The council could have tried to give it some status, for example, at the 31st of May 2018 meeting, but they didn't. So, to summarise, sir, in my view, our view, the 2017 draft does not have any status or weight and is not a material consideration in this appeal. Those are my preliminary comments, position. If we have looked at appeal decisions, and you may wish to consider those or at a later time, but that's my main thrust of my argument.
Right. Anything further, Mr. Thompson, before I move to the council? There are following questions of if that is correct, what other options are open, but just focusing on this for the moment.
There are one or two elaborations that might be helpful if I made at this stage, sir. The first is that the appellant's attack on the 2017 draft has two prongs. One, the first one, the one that's just been explained by Mr. McCafferty, that the council has chosen to give the document no status. It could have tried to adopt it as something, but it didn't. The second prong of the attack is that even if they had, it would have been unlawful. And it's unlawful, among other reasons, because it doesn't comply with the tests in the circular. And the appellant's detailed criticism of that is set out, I think, in the schedule to the supplementary hearing statement. But for present purposes, I should perhaps focus on the first one, whether it has any status at all. And I entirely agree with Mr. McCafferty's position that the 2017 draft effectively ran out of steam and status the moment that the direction was given by the Scottish ministers. One is familiar with draft LDPs and before that draft local plans, which as they neared adoption were treated as material considerations in planning applications because they were a clear indication of what the council's policy intentions were. And the weight that you gave to them increased the nearer you got to the point of adoption. And there would be the stage of the consultation and then the examination and the acceptance of the examination findings, and all the way in my submission that the weight increased. But if one thinks of what would have happened to a local plan that the ministers said, don't adopt it, they might say, don't adopt the retail chapter, but the rest of it's fine. But in my submission, it's the same sort of issue of trying to breathe some sort of life back into the 2017 draft after the council was directed not to adopt it. And the point about competency is that Section 22 of the 1997 Act introduced for the first time supplementary guidance as a creature of statute. And in subsection 9, it effectively permitted the continued use of non-statutory guidance. And that was to be called planning guidance as opposed to supplementary guidance. And the point is that Section 22, subsection 2, provides that regulations may make provision as to the matters which may be dealt with in such guidance. By the 2008 Tanner Country Planning, Development Planning Scotland Regulations 2008, which is OMN 209. And Regulation 27 provides that supplementary guidance adopted and issued under Section 22(1) of the Act in connection with a particular strategic development plan or local development plan may only deal with the provision of further information or detail in respect to the policies or proposals set out in the plan, and then only provided that those are matters which are expressly identified in a statement contained in the plan as as matters which are to be dealt with in supplementary guidance. And I don't think it's questioned by the Council that the LDP that we're concerned with does indeed require supplementary guidance to provide the mechanism for developer contributions. If one pictures the tiers of the development plan, there's the strategic development plan, the local development plan, and supplementary guidance. And what we submit as happened here is that we've got the strategic development plan, the local development plan, but no supplementary guidance on the topic of developer contributions. And that's an omission, a lacuna in the development plan, which cannot be filled. And indeed, the Council, as I understand, doesn't suggest that it can be filled. What they say is, well, here's this old draft from 2017. We'll call it non-statutory guidance and hope that everybody agrees to pay it. Now, the first point is the competency one. It's not, the 2017 draft is not supplementary guidance because of the direction and because it wasn't adopted as such. It's no longer a draft in the sense that it's not going anywhere because of the direction. The Council could have tried to adopt it as non-statutory planning guidance on the view that that's permitted by Section 22, subsection 9. But that, in my submission, doesn't work because of the restriction of the scope of supplementary guidance in Regulation 27, and hence the only matters that can be covered by non-statutory planning guidance are matters which aren't the subject of supplementary guidance. You can't use non-statutory planning guidance as a safety net if you can't get supplementary guidance. And that's why we submit that at that important meeting in May 2018, when the Council had to decide what to do after the receipt of the direction, they could have decided to start again, which they didn't. They could have decided to brazen it out and adopt it anyway. That, perhaps wisely, they didn't do. They could have thought of adopting it as draft supplementary guidance if they thought they would try again to persuade the ministers to let them adopt it. They might have tried to dig up some more reasoning to satisfy the ministers that it was competent, lawful, and they might have consulted on that new material, which might have let them try again. Or they could have said, well, we'll ignore Regulation 27 and we'll call it non-statutory planning guidance. And we'll adopt it as such. Now, perhaps wisely, they didn't do that either. Firstly, because it would have been incompetent in my submission to do so. And secondly, it would have been pretty rash, if you think about it, that having been told not to adopt it as supplementary guidance, they should then turn around and adopt it as non-statutory guidance. But in any event, they didn't do that. And in my submission, it's critical for any planning guidance to have any status that it has to be adopted. And that's what hasn't happened, either in relation to supplementary guidance or non-statutory planning guidance. The importance of all this becomes clearer when one looks at the actual terms of the direction, which is OMN 63. The direction was not to adopt and not to issue a supplementary guidance, which we know as the 2017 draft. And then it's explained that there was insufficient information either before the ministers or consultees to enable them to tell if it complied with the requirements of the circular. And then the next paragraph, which isn't mentioned at all in the report to committee in May 2018, we would therefore request that the new supplementary guidance is prepared following statutory procedures, and for information regarding the approach taken, the justification and methodology for the developer contribution zone to be made available as part of the consultation process. In preparing new supplementary guidance, we would also reiterate the need to consider, first, the tests set out in Circular 3 of 2012, secondly, the need to adhere to principles of good public involvement in supplementary guidance as required by Circular 6 of 2013, and the fact that there is no provision in legislation to update supplementary guidance in future without carrying out the necessary consultation. And that may be relevant because there was a provision in the 2017 draft suggesting an annual review. And that might have been a hint from the ministers that that might be difficult to carry out in practice because of the need to go through the consultation process to stay within Section 22. But when one then looks at the report of what happened on the 31st of May, in the legal and risk implications section, there's the risk of a policy gap arising if the supplementary guidance is not updated and adopted to reflect and provide additional detail on the approved local development plan. And of course that is absolutely correct. So this is N183. And it's the paragraph at the foot of page 15. Particularly the last sentence at the bottom of page 15. Submission, that's clear. Then the background starts at 1.1 at the bottom of page 16, and we go over to paragraph 1.5 on page 17. And they were told that it couldn't be adopted. In February 2017, the Executive Committee approved the draft version of updated guidance for consultation, and that's true. And it was consulted upon, and thereafter some changes were made arising from the consultation and were submitted to the Scottish ministers. But that, in my submission, was all that it was approved for in February 2017. And of course, at that point in February 2017, the members didn't even know what the final version was going to be because they couldn't prejudge the result of the consultation process, and they delegated authority to an officer if it wasn't, if nothing unduly dramatic emerged from the consultation process, to give effect to it, wrap it up in a bundle and send it off to the ministers, which is what happened in December 2017. And then they're told the Scottish ministers responded in February 2018, indicating that the council could not move to adopt the guidance. And then the really interesting part, the Scottish Parliament is currently considering a planning bill which is likely to introduce substantial policy changes relating to developer obligations. And that, of course, are the levy, the infrastructure levy provisions, which are in Part 5 now of the Planning Act of 2019, but have not yet been brought into force. And the latest indications from the government are that they won't be moving to consider that until, I think, the third quarter of 2022 and throughout 2023. Now, at that time, in May 2018, thinking about the options open to the council, they knew what had happened in the direction. They knew about ELSIC. They might reasonably have had doubts about whether a scheme using the sort of zones that their 2017 draft was using would be likely to get any further, even if they did try again on the same general basis. But they then thought, there's a planning bill which is about to change the law and permit infrastructure levies. And of course, you will recall, sir, that there were hints in both, I think, the Inner House and certainly the Supreme Court that there were perfectly good reasons why a pooled fund scheme for major traffic interventions might be a good thing, but it wasn't the law yet. And the purpose of my submission of the infrastructure levy provision was to enable such a pool fund scheme to become legal. And one could understand that it might have looked like the answer to a prayer that the law might change to make the scheme that had just been turned down by the ministers to be viable and acceptable and lawful. And that was certainly the heavy hint that was in this report at that sentence. And then one looks at the minute following that meeting, and it's OMN 183. And this matter is dealt with at paragraph 39 on the second page of OMN 183. And the heading is Updating FIFE's Planning Guidance. The committee considered a report by the Head of Economy, Planning and Employability Services, providing an update on FIFE's planning guidance, proposing action in relation to the Council's statutory supplementary guidance, which would provide important detail on how to interpret policies in the local development plan, and advising that the Scottish Parliament was currently considering a planning bill which was likely to introduce substantial changes, and that the Council had been advised by the ministers that it could not move to adopt the supplementary guidance on planning obligations as set out in paragraph 1.5 of the report. Now, reading that without having looked at the report first, one might be forgiven for thinking that the reason for the minister's direction was that the law was about to change. But of course, it's the other way round. But the significant point is what's said in the decision. And there is absolutely no decision relating to the guidance on developer contributions. So there's an absence of decision to do anything other than do nothing. And the reason for doing nothing is the belief that the law may change to make the 2017 draft become lawful. And if that was the hope, it's perfectly understandable that the Council wouldn't have moved to adopt anything. They wouldn't have adopted non-statutory, statutory, anything else. Now, our researchers have failed to disclose any subsequent decision by the Council or any committee of the Council to give any status to the 2017 draft. As far as we can see, it hasn't been adopted as anything. So against that background, when one looks back at the February 2017 report, OMN 184, one sees the very limited scope of the approval approved for the purposes of consultation. And again, at the top of page 162 in 184, under the legal and risk implications, any such guidance will form part of the development plan and have that status for decision-making in line with Section 25 of the Planning Act. There is a risk of a policy gap arising if the supplementary guidance is not updated and adopted to reflect and provide additional detail on the approved local development plan. And again, that's exactly what's happened. And again, to be blunt about it, the LDP doesn't work without the supplementary guidance. And then one sees at paragraph 3.2 in the conclusions. And of course, sorry, yes, 4. And again, just to think about the timeline here, this was February 2017. The consultation process was in the spring and early summer of 2017. It was sent off to the ministers in December 17, and in the meantime, the LDP had been adopted in, I think, September 17. So one of the things that had to be considered was what they were going to do about applications that were pending and coming to determination during the summer of 2017 before they got their supplementary guidance in place, which they would reasonably have expected to have happened within 28 days or whenever they sent it off in December 2017. So they would have expected or hoped to be able to adopt in January 2018. And at paragraph 3.2, they say the revision and adoption of the supplementary guidance will ensure that Fife has up-to-date policy coverage and will assist in the delivery of the Fife Development Plan strategy. The revised guidance will not be adopted policy and will not be legally enforceable until ministerial approval has been received. Developers will, however, be requested to use the updated planning obligations supplementary guidance on a voluntary basis ahead of its formal adoption from the date of its approval in committee for consultation. If they are not willing to agree to these contributions on a voluntary basis, the Council may require to defer consideration of their planning applications until the revised guidance is approved, there is a consequential risk of appeals being submitted to the Scottish Government on the grounds of non-determination. And of course that's perfectly understandable. And the concern would have been, until the hoped-for adoption, the argument would have been that the draft, which was getting very close to adoption, was a material consideration. It wasn't yet part of the development plan, but it would be a material consideration which would justify and make lawful payments at that time. But I must mention all that flew off the moment that the ministers directed them not to adopt the 2017 draft. In a way, it didn't matter what the reason for the direction was. In fact, we know that they weren't satisfied that it had been demonstrated that the scheme was lawful. And you will recall, sir, that there were 2 28-day extensions of time while the Council submitted the various documents which we recovered under the FOI, and that's the subject of a separate paper and various written submissions, and I won't go there again. But it shows that with all the best endeavours of the Council over 3 months, they couldn't persuade the ministers. And that, in my submission, is what's wrong with their position, that it's for developers to prove that they don't have an impact on STIM sites. The starting point is for the Council to bring forward a lawful scheme that addresses the need for proportionality. They say proximity, gravity model, core zone. It's all very well, but one might have expected to see little concentric circles around either the sites or the STIMs to see where they overlapped, even on a simple basis. But there's nothing like it. And that's the second part of our argument, which perhaps I shouldn't get into yet, about the lawfulness of the scheme itself. But at this stage, I'm anxious to explain and make clear what our argument is about status. You, sir, in your procedure notice, requiring comments, I think, leading up to the original hearing date, called it draft supplementary guidance, or non-statutory supplementary guidance. In the latest agenda, it's called non-statutory planning guidance. In my respectful submission, it's neither. It certainly isn't statutory guidance. There is no such thing as non-statutory supplementary guidance. And for the reasons I've tried to explain, neither is there such a thing as non-statutory planning guidance in relation to a matter which ought properly to be the subject of supplementary guidance. And it's when one begins to realise that there's simply an illusion that there's something there, and that the Council has been using this 2017 draft in various ways. It's been telling developers that if they don't make the contribution in the scheme, they won't be recommended for planning permission. Some have gone to appeal, and there's one. It's one of the Aberdeen cases. It's the first one where it's clear that the reporter looked at the question of the transport developer contribution, but he saw that the appellant accepted it. There was no controversy between the Council and the appellant on that subject. He made a passing reference to the circular, but it didn't cause him any concern, and he didn't factor it in his determination or give it any further explanation at all. Similarly, in the Aberdare case that the Aberdare case that the council's relying on, it was conceded there that the 2017 draft was a material consideration. And the debate then was about the weight to be given to it. Now, no such concession is made in this case. We submit that it is not a material consideration, and that's a matter of law, and that's why I'm making this part of the submission. Further, in the Aberdare case, it doesn't appear that the reporter's attention was drawn to the request by the ministers to bring forward new supplementary guidance. He might have taken a different view if he had, and he certainly doesn't explain that part of the direction, which is, on the face of it, inconsistent with any notion that the 2017 draft could have any continuing life at all. Mr. McCafferty has already made the very good point that when one looks at the papers that were put before the Committee of the Council on the 31st of May 2018, after receipt of the direction, there's no reference to the direction itself. So there's no indication that members even had it available to them, that they were relying on what they were told in the report itself. And again, that makes one all the more reluctant to infer that anybody intended to give the 2017 draft any status after the 31st of May. So I've taken up rather a lot of time. If you'd like to indicate which bit you'd like to move on to next, sir.
That's probably, thank you, Richard, it's important to do this. It might be helpful perhaps to take the council's view on what the judge said.
Absolutely.
Thank you, sir. I don't disagree with much of the factual history that my learned friend has set out, but the question for you, sir, is whether to have any regard to the matters within the 2017 draft and the information in it, not to decide what the ministers thought or not of the lawfulness of the supplementary guidance as a potential element of the development plan itself. Obviously, the procedure that was being gone through after or in tandem with the adoption of the LDP was drafting of guidance that was intended under Section 22 to become part of the development plan, and therefore, in terms of making a planning application decision, to become part of the development plan rather than a material consideration. And it was that status that would have been gained had the process had resulted in approval from the ministers. The fact that the ministers issued a direction that the council was not allowed to give the draft guidance that status is not in of itself a decision on the lawfulness of the information within the guidance, and it's not entirely clear whether the ministers were just looking for more information in order to be convinced about the total scheme of the guidance in terms of providing enough information to prove that all the interventions were necessary for all the developments, i.e. that all the developments had a connection with each of the interventions in the way that was brought into sharp focus in ELSIC. Now, I disagree with my learned friend when he says that that just leaves the draft guidance and information in it as an illusion. I do agree that in the meantime there is a gap or a lacuna in the development plan, because obviously policy 4 of the local development plan envisages that there would be statutory supplementary guidance that would give a clear steer towards an exact figure for developer contributions in each instance in terms of this sort of scheme. However, the policy 4 remains in the local development plan, and in my submission, when considering a planning application, the council or the reporter requires to consider whether the application development has an impact on these matters, in particular on traffic, on the traffic network in the area, and whether it has sufficiently mitigated that impact. And the developer contributions scheme was designed to make that process much easier. That has not come to fruition in the sense of becoming part of the adopted local development plan or part of the development plan. But the fact that the ministers issued a direction does not destroy the information in the draft guidance. As my learned friend accepts, in the meantime, when the ministers were considering the adoption of the supplementary guidance, it would have been permissible to look at the draft and take that into consideration as a material consideration. In my submission, sir, it's not that dissimilar a position now where there is a lacuna in the local development plan. You, sir, have to look at what information is available, and this, although obviously the weight that one would afford to the supplementary guidance and the work, or not the work that's gone behind it, but the actual supplementary guidance and how it proposes to deal with that matter, is not wholly irrelevant. In my submission, it is a relevant and material consideration that one can and should take into account, as a number of your colleagues have done in other proposed developments in this planning authority area. I don't think I need to say anything more. I acknowledge that there has not been a formal status given to it by the council since the direction was issued, but that does not make it unreasonable to take it into consideration when trying to decide how to deal with this issue in other planning applications.
So in a sense you are drawing a distinction between the draft document itself as one thing and then the work that has gone on in preparing that as a second, and that it's the work which has gone into it which you are say should have attached a value as a material consideration.
It certainly does, sir, in my submission, and one could look at how that was envisaged to work, and you, sir, have to decide in this particular instance how to deal with this issue, not to make an overriding decision about the supplementary guidance and what has happened to it. You have to look at the question of the off-site impacts of this development and decide whether they have been found to be acceptable, and look at ways in which it's been proposed that they might be acceptable, and take into account the council's position that it would be satisfied if it were dealt with in the way that had been envisaged by the supplementary guidance. And you, sir, have to do that now, looking at the matter when you're taking this decision. So obviously you can give less weight to the supplementary guidance because it's no longer an adopted policy. But you have to look at the thinking behind it and also the current situation on the ground, and indeed in terms potentially if we're going back to the drawing board to look at the other changes in terms of cost, etc., of the interventions. But the underlying information about what interventions would be needed remains, and in my submission we'll maybe here has been looked at again and been updated to establish in relation to this particular development whether there is a direct relationship between this development and the proposed STIMs.
Please correct me if I'm wrong, but I think it had been the appellant's position that to reach, let's call it an accommodation on developer contributions, would effectively be undertaking an action which was not lawful. Is that correct?
Yes, Sam. In my submission, attractive as my learned friend's suggestion about how this might become a material consideration, the difficulty is that the draft includes policy decisions. It's not just about modelling or methodology. And I'm thinking particularly of the so-called exemptions for affordable housing and employment land. In my submission, whatever view one takes of modelling, those so-called exemptions are blatantly unfair and unreasonable and distort any attempt at proportionality, because they're not exemptions in the sense that that share of the cost of STIMs is going to be borne by the council. They're being heaped onto the developers of the employment land. One is being heaped onto the housing developers. Now that's a policy decision that's got nothing to do with the modelling. And the question is, does that policy decision on exemptions, does it exist at all? It was put in a draft that the council was then told not to adopt. And no attempt has been made to revisit that. It's not a council policy, as far as I can see, to transfer the cost of the impact of affordable housing and employment land onto the developers of market housing. And that's why, in my submission, the omission of any adoption of this is absolutely fatal. It can't just lie there and be kicked around and used if it's not the policy of the council. And in my submission, the council would have had to have taken a decision about how they were going to use it in full knowledge of the facts. What they were allowed to do in terms of Section 22 on non-statutory planning guidance, what they should have made of the direction, and if they had decided to adopt it in any shape or form, that of course would have been a decision which could have been judicially challenged. But because it's just laying there and being used by the council or by officers of the council, my own friends are able to say, well, people have made payments, reporters have looked at it, but I don't think any reporter has heard the argument that I'm submitting.
Normally, a reporter, if considering a matter of payments, and normally these things come to us as agreed by between developers and councils, the reporter would make a reference in what would in fact be a notice of intention in setting out what has been requested would set out a reference to the foundation for the request in terms of a development plan, and normally you'd perhaps refer to a specific policy or supplementary guidance. What would be the foundation, and I'm looking to the Council now, effectively for that decision by a reporter if that was the way that this was to go?
Well, sorry, in my submission it would still be policy 4, although not with the benefit of the more detailed guidance that would have come through as a supplementary guidance.
I think probably I've heard as much as I'm going to on this particular issue, and that I shall have to go away and consider very carefully what has been said on both sides, and look more specifically at the judgments that have been quoted.
Yeah. The only point that I'd make in response to that last point was that Policy 4 doesn't work without the mechanism.
That was the essence of my question.
No.
Now, setting aside that debate just for the moment, the appellant had made a number of comments about the purpose of funds, the infrastructure investment fund, so on the Northern Link Road, which, although we've made progress on that, we'd said would still be seen as a contribution. And I wonder if you perhaps like to take the discussion forward on those matters and what you think particularly would be appropriate or not appropriate in this regard.
I don't mean to appear to be sidestepping that question, sir, but it might be helpful to hear from Mr. Ralston and our modeller about what the basis of the scheme in the 2017 draft was and what might have been a lawful scheme. I'm not sure if that's...
I'm happy to do that.
That might help provide the foundation for what I might want to say later.
Right, no, I'm happy to do that.
Yeah. Mr. Ralston, could you help us then on what's wrong with, according to the appellants, what's wrong with the 2017 draft, and what would be the basis of a lawful scheme?
Okay. There's a lot of detail to cover here, and I'll try and maintain the arguments at a kind of higher level to start with. I may rely on Mr. Bagnall supporting some of the detail of that in terms of the modelling in particular and what the model can and cannot do. But in very simple terms, the Council's methodology that they've applied to this has been a very simple blanket methodology, which has created an arbitrary zone around the Dunfermline settlement and called that the core zone, and then applied percentage weightings across the zone, and then to what they refer to as an inner zone, which is beyond that core zone, and then an outer zone with weightings applied. They've then taken the affordable elements of that and removed it from the calculation. So they work with a net figure, and they take the total STIM calculations and divide it by the net figure of private units. So the affordable units being stripped out. What we're suggesting is that is a very simple methodology, and that they had a tool available to them, which would have been to use the Paramix model in particular in more detail to give relevance to the proximity and the proportionality related to each and every STIM. By grouping them, they're suggesting that they're all near to each other. But obviously, in terms of the geography, some sites are nearer to a group of STIMs than all of the STIMs. So we think that there is an issue with that in terms of the availability of information available to the Council and the option not to use that information to make it more proportionate. The only thing that we have found, and if I could point you to a document that was prepared, which is FC 71, which was in October 2019, and in particular to paragraphs 1.9 and 2.4. And in that document, there is reference from the Council about an association from our site to particular STIMs. Not to all of the STIMs, but to particular STIMs, which, just to be clear, I can refer to as Petrevie Roundabout, Bothwell Gardens Roundabout, and Broad Street, Elgin Street, Signalised Junction. The Council then goes on in that document to suggest that there would be appropriate trigger points that would link the site with those STIMs. Now, it's a wee bit confusing in terms of how this has been prepared, because it refers to 3 sites, but actually documents 4. So the 3 sites were the 3 that I previously cited, Petrevie, Bothwell Gardens and Broad Street. But they also add in a connection to, or a relationship with, the NLR at the very eastern end, which, for the avoidance of doubt, is the section beyond Hallbeath to the roundabout, which includes a bridge crossing off the railway line. We think that as a result of what the Council is suggesting, that there's a bit of a dilemma in terms of grouping everything to say it all associates with all STIMs, and then having trigger points where the interventions are pointed out relative to the site. So there's a slight contradiction in terms of association. And I think in general terms, that's where there's a difficulty beyond what we've already referred to, which was the nearest STIMs to the site, which we've spoken about before lunch. In terms of how the model works and what the model enables the Council to do, it's probably better that I ask Mr Bagnall to explain a wee bit more detail about the modelling aspects.
Okay. In very simple terms, we talked about distribution this morning. So every development will have a distribution associated with it. We're not looking to pick holes or cast any doubts on what the work that SIS and Sistra did to determine that. That distribution is then used to route vehicles through the network, which is called assignment. And you can actually undertake a piece of analysis called select link analysis, where you pick a link or a selection of links on the network, and it will tell you those trips, where they came from, where they go to. If you then do that analysis, you can then trace back individual links, i.e. STIM locations, and where the impacts are coming from. And you can layer that, so you can layer that to the developments, you can layer it to base traffic, so what was there when the model was built, for instance, or a particular base year that you decide. And you can also layer in the middle background growth. So that could be just general people making trips, perhaps sites that were granted before LDP came along. So those 3 layers then, if you subdivide them, apply this select link analysis, you can actually identify the relationship between the bits of the network and where the traffic is coming from or going to ultimately. and therefore calculate the proportion. And I would counter that it's extremely unlikely that you will end up with an equal proportion of trip assignment, traffic impact, the cost of the STIMs, and also the exempted land uses as well. Because at the moment it assumes if everyone was to pay an equal proportion, then they all also have an equal proportion of affordable housing, for instance, or employment land. So that's another key point. Yep.
I could also point you to some information that the Council supplied to us at a point in time, which was FC 49. And within FC 49, there was some information provided as evidence of why the appeal site is related to all the STIMs. Well, first of all, not all of the STIMs are listed on FC 49. It appears that one in particular has been omitted. Whether that's by choice or default, I'm not sure, but one of the junctions on the west side was not listed. However, the benefit of this from the Council's perspective was to prove that there were trips, additional trips, derived from the site that passed through each and every STIM. We would like to point out that only 3 sites were considered within FC 49. There's 3 sites being Wellwood site, the NH Brown site, which is done 35, Hallbeath, which was done 43, and the appeal site. And those figures show remarkably small numbers, very tenuous links, in particular to the Western Distributor Road, of which, by accounts of the output of the model, and we must acknowledge that we don't know what scenario was run in the model, it was a very simple kind of output that was provided to us, but they were suggesting that 2 or 1 trips would be associated with the Western Distributor Road. In our opinion, that is a very, very small and almost negligible figure in terms of relationship. And earlier today you heard some evidence about distribution. And distribution is particularly important in terms of the model. And the mystic within the model is only visible to people that have the model. We have looked at some kind of assignment and believe that if you were to use some other methods that have been used in other sites, particularly Cuddy House, which was a recent application that was made, they have relied upon DataShine commute information to give an idea of movements to and from their site. What that does is it gives you strategic information pulled from travel to work from the 2011 census. If we applied that to our site, the figures that you heard earlier would change. Now, what we do know is that they've given very general information about whether the movements would be north, south, east and west. But what we would contest is that if people leaving the appeal site would move directly south, through the Carnegie Drive junction, are unlikely to go west before they go south. So the generalities of those percentages are slightly questionable. And what we would have preferred, would have been clarity on the relationships. We had no ability as a small site, as an appeal site, to do a similar task and provide an alternative microsimulation model, and therefore we've relied on percentage impacts and desktop appraisals as we've previously cited. I think beyond that, there's more detail that we could discuss, but I think that's enough for the moment.
I don't know if that's sufficient for you, sir, at this stage, or if you've got any particular question for me.
Just put down a mark, and I'm not sure it answered the second part of what Mr. Thompson indicated was what would be accepted to be lawful, assuming they're saying that if this more detailed examination of the percentage impact on each STIM was then redistributed amongst the developments, they'd wouldn't have a problem with that. But I'll just put that down as a marker and perhaps ask, I think it's probably Mr McGilvery to speak to sorry, Mr Malcolm about the content of the detail on the modelling and FC45.
Thank you. Just with respect to the background for FC49 and the data that's included for done 35, 43 and 44, to confirm that analysis was undertaken using the methodology Mr Bagnall mentioned with respect to the sort of select link analysis. And it does demonstrate the relationship between the land north of Wellwood and all the stems. The impact in some cases, or the flow across the stems in some cases, is small, but it's proportionate to the level of capacity for that land parcel. I just wanted to mention as well that the stems as solutions to mitigate the local development plan is quite a complex relationship that the stems do. You know, it's a cumulative assessment that's been undertaken, which is reported in OMN 108 and 110. And the mitigation and the solutions to mitigate the impact of the development plan is complex, and the different stems interact with each other in some respects. The final part was that this analysis is part of, there's wider analysis being done on all the sites within Dunfermline and the relationship with all the stems. And the conclusion of that has been that there is an interaction between the two, and also that they follow the sort of general gravity principle that in some cases the closer you are to a particular stem from a development, the larger the trip impact, and equally further away, less so. And it's broadly the same principle across the whole network.
Sorry, sir, just before moving on, I think Mr Shan might make a comment about why it's only the 3 that were shown in the extract.
Just to clarify, the reason there's only 3 there is because they relate to the statement that we made, the council made, with regards to showing the impact of the development proportionally. So within our statement, we reference the Holbeath Road, Whitefield Road, and we reference the Petrevie roundabout and the traffic impacts and triggers associated with the other two sites named there. So it was just to give that reference. That's why there's no other sites mentioned there. It's just showing that relative distribution of those 2 sites, because those were referenced in the council statement. That's the only reason.
We've had very strong statements on both sides, and I've heard from you particularly arguments as to why the request for developer contributions is not lawful in terms of the guidance and so on. And the council's view about the impact from the site on stims and other matters. And it is an acknowledged system now for developer contributions, and just setting aside for the moment how they're reached and the legality of that reaching. But is it the case that the appellant is arguing that it should not have to pay developer contributions at all? Or is it simply that your argument is against the way that it has been done and that in its sense is unlawful? I'm trying to explore any ways forward without any prejudice to what I might determine or not at the end of the day.
As I mentioned before lunch, our position about building the stretch of NLR across the site, the appellants are happy to do that and to construct it to an LLR standard, whereas all that would be required for connectivity and for planning reasons would be a through road to link the sites and provide mobility and access and so on. And the developers, the appellants recognise that there may be some de minimis impact beyond the proximate junctions which are already dealt with. But they have no way of quantifying it, and I submit neither does the Council. And it's for that reason that the appellants are prepared to construct to an NLR standard, which they submit is greater than is actually required for their development. And that uplift in cost and land take is an acknowledgement of that de minimis contribution. That's the appellant's attempt to go the extra step to assist in this problem. You've quite rightly identified, sir, that the difficulty is that unless there's a lawful basis, the appellants can't agree and you can't require, because of the rules against buying and selling planning permission. That's why the offer of going to the NLR standard was carefully considered. What we've heard about proximity and so on, one has no difficulty with the principle of proximity. It's pretty obvious that the closer a development is to a STIM site, the more likely it is to aggravate any problem there. But when one looks at the map of the whole area, some of the sites are a lot further away from STIM sites than others. And the cost of the STIMs is the same for each site. So someone might have a large impact on an expensive STIM, and someone else might have a small impact on a very inexpensive STIM. And that's the problem that we seek to highlight. And the extract that Mr. Alston, Mr. McKenzie referred to, illustrates that the impact on the Western Distributor Road, for example, is 1 or 2 trips out of more than 1,000, whereas there may be 12 out of hundreds somewhere else. Now that, in my submission, clearly illustrates that you can't have a one-size-fits-all. You can't assume that by charging £5,332 per roof, you'll achieve any sort of proportionality, even if that was the right sum, which we submitted isn't because of the exemptions. We've seen the Council's concern, Mr. Shand is concerned that even 1%, if somebody shirks their 1% and that's loaded on to everybody else, that's unfair. But it's not nearly as unfair as 25% and the employment land being heaped on somebody else. So there are fundamental reasons why the scheme's unlawful, and then there are modelling ones, and I confess that nothing that I've heard today has persuaded me, or I suspect any of our Stantec representatives, that the flat roof tax levy proposed on sort bears any relationship to the impact of the appeal site on any particular stim. Bearing in mind that they're all have different price tags on them. So in short, sir, the appellant can't go further than it's gone. And the council will have to consider the consequences of the position that it's got itself into.
Comment.
Just comment on that, sir, that I think that there are two issues merging into one there. Your question was whether the appellants would accept that there is potential for a lawful contribution to be made. In my submission, they have accepted, not least by offering what they regard as some sort of contribution through the upgrade to the through road, that a contribution to the STIMs or off-site effect of their development is lawful. What they are saying is they're not sure that the methodology that has been proposed by the council to ascertain the amount that is appropriate is correct, and therefore they seem to be saying that nothing is due. And those are two different things. They give the example that they may have a lesser effect on the western distributor road. By the same token, they will have a greater effect on the NLR itself, because they are right next to it and part of that. So it is always going to be swings and roundabouts, and someone has to decide how to come to the level of contribution, as opposed to whether any contribution is due at all. The council have tried to do that, and you sort of have to decide in relation to the way that has been done. But the fact that they are disputing the detail of that is not the same as saying no contribution is due. And the fact that they haven't given an alternative, again, doesn't mean that nothing is due, sir. I mean, the figures, I think Mr. Rawson acknowledged it's a very difficult exercise. The figures will always be changing. The number of houses will be changing. The cost of the STIMs will always be changing. And to at any one point in time come to a decision that gives to an exact amount will always be a difficult exercise. But if they are accepting that in principle they would be due a contribution, then that might be a matter that can be moved forward as well.
Thank you. Let's just take a comfort break whilst I ponder that, and let's come back at 5 minutes to 3. I think we could go on discussing these issues further, but in one respect we've reached something of an impasse. I think it's incumbent on everyone to try and use the planning system in a way which benefits not just the whole country, local areas, people that live there and so on, which is done basically through the development plan system. And in this case, we have a situation where there is no dispute over the principle of what the appellant is trying to achieve through development of the site. I know there are issues to be resolved, but the principle is there. Through an allocation in the development plan, and against that background, it should not be outwith the capabilities of everyone around the table to be able to reach a conclusion which would enable the development plan in this respect to come to fruition. That, after all, is the purpose of the development plan in the first place. Now, without prejudice to what my determination may be, I think it's incumbent on me, as far as possible, unless there are very good grounds not to try and achieve a solution whereby the aims of the development plan can be fulfilled. Now, there are areas where, as I understand it, the applicant doesn't have difficulty over the principle of contributions. There's education, public art and so on, although the amounts would have to be addressed, but that's not the issue now. And one way forward for me, well, I have two options. One is to dismiss the appeal, which then means the appellant, the developer, has to go back to square one, and in doing so would need the help of the council in doing that to achieve a solution. Another way forward would be to allow the appeal and serve a notice of attention, which would need further discussions on a lot of the matters which we've discussed today to reach an agreement on an obligation for the appellant to make suitable contributions to reflect the impact of its development. Where, and without drawing any conclusions, but just looking at some of the things that we've talked about today in terms of the development plan, and I'm reading now from the development plan at Policy 4, Planning Obligations. Development contributions will be sought in relation to development proposals that will have an adverse impact on infrastructure capacity. The kinds of infrastructure to which this policy applies includes transport, schools, affordable housing, green space, public art and employment land. The contributions will mitigate development by making a contribution to existing infrastructure or providing additional capacity or improving existing infrastructure or providing new infrastructure. This will be applied through planning conditions, legal agreements and planning obligations. Now, so far, I don't think there's any difficulty on either side. It then goes on, planning obligations, supplementary guidance will be prepared. The guidance will contain details of how impacts will be assessed and how amounts of development contributions will be calculated in relation to transport, etc., etc., etc. So, at this stage, we don't have any guidance, either statutory or non-statutory or whatever, which gives any indication of where we go. Now, to a certain extent, there's perhaps a gap in the policy in that it doesn't say how we should proceed in the event that that supplementary guidance is not prepared. That doesn't appear to say that there may be mechanisms whereby sides can agree on whether or not contributions should be made and at what levels. Now, if I'm minded to allow the appeal, and I'm not foreshadowing what my determination is going to be, it would have to be by means of a notice of intention regarding a planning obligation. That obligation could be an agreement between the two sides, or it could be a universal obligation on the part of the appellant as to what it was prepared to offer. But it appears to me that we are not going to resolve matters this afternoon in terms of an accommodation, because I think as things stand at this particular time, I think the distance between the two parties is too great, and that to reach an accommodation of whatever would need a period of reflection, which a notice of intention could provide. So basically, in a sense, summing up from my point of view, there are those two options. There is dismissal of the appeal and back to the drawing board and further discussions, or there's an indication to allow the appeal, but subject to an appropriate obligation to be worked out or not. And bearing in mind that if a notice of intention is served, that does not preclude the eventual refusal of the appeal, because on the grounds that a satisfactory accommodation cannot be met or agreed. It's perhaps a slightly unusual statement for a report to make, because inevitably it gives an indication of some alternative thinking that I would have to look at in moving forward. I think perhaps I might ask the appellant first, and I'm bearing in mind there's going to be summing up and there may be further things we want to discuss anyway. But I wonder, Mr. Thompson, if you would have any comments on those thoughts.
I would have to take instructions before I could say anything. I sympathise with the position, sir, but as I indicated, we've been trying to get planning permission for a very long time. This appeal has been ongoing for a very long time. A lot of expense has been incurred in the appeal process, and the appellant is anxious to have a resolution. If it turned out that it was a point of law that was between us, it would be a legal challenge of whatever decision was made if you took a particular view, which is another option. But subject to taking further instructions, my view at the moment is that the appellant would not wish to delay unduly. I should say that there have been false dawns of discussions between the parties, because, like you said, it seemed to be an insoluble problem. But there hasn't been any sign of any softening in the Council's approach to 5332 or nothing. And in a way, one could understand that position of the council if they're afraid that if they give way once, they might not be able to hold the line on what I would think of as a bluff that they're running with the 2017 draft. So I had assumed that that was what might have been causing a lack of progress with any sort of settlement discussion. And I don't know if that's still the position or whether they may have softened as a result of your observations today, Sam.
Also, obviously need to take instructions, but obviously I acknowledge that what you said makes perfect sense, and I had understood that there was scope, and always has been scope for discussion between the parties, so I'm slightly surprised that it's been purely put at the door of the council, that no progress has been made, or to the suggestion that the council are perpetrating a bluff. But so I obviously take on board what you say, and I don't know if matters may move more quickly now, but as I say, I need to take instructions and perhaps have a discussion with my lawyer friend as well.
I would have thought that half an hour might be useful, Sarah, just to, if either side is at an entrenched position before that, we can come back and resume. But I'm certainly happy to use that time in that way.
So absolutely, it might help clarify where we are.
And reconvene. We'll give you 35 minutes. Let's adjourn. Let's reconvene at 3:45, and let's hope there's perhaps been some scope for progress. Thank you. Thank you very much, ladies and gentlemen. I'm not sure who would like to start.
I'm happy to just say.
Thank you.
We're grateful for the opportunity to have an informal discussion. There seems to be a willingness to proceed with discussions, but that won't happen today for various reasons that I'm sure you can imagine. What is proposed is that a fixed date is arranged before Christmas for a meeting to be held between authorised parties on both sides to discuss what you said before the break. One can't prejudge the outcome, but we can certainly try by fixing a date and by lining up the appropriate personnel on both sides. What I think we would both propose or suggest is that you might take the opportunity of asking any more questions, particular questions this afternoon about the agenda items. Thereafter, parties would inform your office whether any progress had been made, and if there was no progress, then you would have to proceed as you thought fit. If some sort of agreement was reached, then you would be informed of the details, and you could then consider whether you would consider it appropriate to set them out in a notice of intention.
I've nothing further to add other than I haven't been able to ascertain whether or any particular date when anything might be done, or if that's a major difficulty before Christmas. But we will obviously investigate that as a matter of urgency.
Think there's anything more that I would wish to ask at this stage this afternoon. There may be issues on education that need a further written request, but I think that anything that's left on the agenda would be matters which will be taken account of in your subsequent discussions. So in terms of the hearing, you said that, Mr. Thompson, and I say you sort of collectively, would respond in writing after you've had your opportunity for discussions. So I think probably we've reached or are reaching the end of the life of this hearing, and that I could close the hearing when we've had final comments, rather than leaving it open for a further meeting, because if that could be dealt with in writing, and from the sound of what you've said, that's probably the best way forward. And my future actions would then depend on what came out of those further discussions, which hopefully would be constructive. Would parties be happy then with that? I think that's effectively echoing what you have said. In which case, Mr. Burnett, are there any final comments you would like to make before we close the hearing?
Sir, in light of that proposal, I wouldn't intend to make any final comments at the moment, but perhaps reserve the right to put something more in writing if matters need to progress.
Thank you. Mr. Thompson?
I'd be happy to proceed on the same basis. I think you have a clear picture of our position already, Sam.
Well, thank you very much for that, everyone. We've had, I think, from my perspective, a very helpful discussion today with contributions from both sides. Whilst perhaps I have taken a slightly unconventional approach, from what has just been said, I hope that it might lead us towards a potential resolution of this that would allow us to go forward with the development of the site without unnecessary due delay, given that it is an allocated site and there is no dispute over the basic principles. And hopefully, following your discussions, I would hope to be able to take matters forward, which would enable us to reach what would hopefully be an agreed conclusion on both sides. So it would be helpful if my office could be informed of a date when you're going to sit down and discuss, let's say, options. And then if it was possible for my office to have a notice of the outcome of those before Christmas, that would be helpful. If it's just into the new year, so be it. But I think in the meantime, it gives us a way forward, and I will postpone any further consideration of my determination until I've heard the outcome of those discussions, and then I can decide then whether I can proceed on the basis of that or whether it might need a further information request. to clarify matters. Is everybody happy with that, Mr. Burnett?
Yes, thank you, sir.
Mr. Thompson?
Yes, sir, and thank you for your assistance today, sir.
So it simply remains for me to thank you all. I hope you have a COVID-free Christmas, and go and get your jabs if you haven't already had them. Thank you very much, everybody.